State Mr. Lordship, the matter has been pending in your Lordship's list for months together.
Is it a commercial matter?
No, it's a civil suit. Lord, it's not commercial. I'm plaintiff.
Non-commercial matter. It is. I am not having the determination. This court is not having the determination.
Basically, your Lordships kindly to mention a matter, your Lordship. I must indicate at the very inception, this is a regular civil suit. However, your Lordship, the order passed by your Lordship for drawing up a decree in terms of the settlement that was proffered to your Lordship. This was made returnable on the 27th of March upon the master submitting a report to this court. Your Lordship, the only embargo that I'm facing now is that your Lordship had kept it under the heading for orders for it to be heard out only on the limited conspectus if stamp duty is payable.
Yes,
Your Lordship. If I may just hand over.
But now this court is not having
Your
determination.
Lordship, the only limited because your Lordship, it was your
That's
Lordship.
correct. That's correct.
I appreciate. I bow
I
down to your
appreciate you are relying upon the Supreme Court
Supreme Court
judgment
judgment.
from this
Thankfully for-
Madhya Pradesh High Court.
Yes, your Lord.
For the partition
Lordship,
suit, the
thankfully-
stamp duty is not required. That is.
Yes, your Lordship. Thankfully for the passage of time, your Lordship.
But unless it is assigned, it is not a part-heard matter.
It's not a part-heard matter, your Lordship had passed the order. Just in that respect, if I may just.
But I so much can't.
I bow down to your Lordship.
Sorry.
My lord,
Grateful.
mention one thing, my lord. My lord, on 17th March 2025, our order was passed that up to 14th April, I can file my evidence, my lord. But for 11 to 14, there was holiday, my lord. So, my lord, I am bringing
Commercial matter.
my lord, commercial
What do you have to file?
evidence.
Affidavit of evidence. When the matter is fixed for evidence.
My lord, fixed on 12th June 2020.
You saw the copy. Come on that day. Show the copy.
Your lordship, I can affirm this one, my lord.
Yes, affirm mention. Affirm it. The office is not. They are not allowing to affirm it. How the oath commissioner will know that there is a date of. It can be affirmed whether it has to be accepted or not. That the court will decide. Come on that day after serving the copy. If they are not receiving the copy, then come. Then we'll see to that. Expertise. Okay, you affirm and come.
My lord, with my lord's permission, I am mentioning a matter which was a PLA matter, which was heard by lordship. After that, the determination was changed. Now the matter was specially assigned before your lordship.
Specially assigned.
Yes, my lord.
कौन सा matter है?
Kindly keep it.
Yes. Call the list.
I'm appearing for the plaintiff, Lordship. Virtually, Lordship will kindly excuse me.
I'll appear for the statement.
I have considered the evidence and all the document. I find that the plaintiff is entitled to 12 lakh rupees with regard to the extra work, but she is not entitled to compensation and the damages.
Grateful to Lordship.
I'm grateful. I'm grateful.
Lordship is provide any interest
Interest also. From the date of filing till the realization.
at the rate of
9%.
Lordship.
I'm grateful. Much obliged.
Just come at my instance, Lordship recollects this. Lordship had allowed an amendment application by which I had amended the plaint to bring on record the previous facts that has occurred during the pendency of the suit, and that was allowed by your Lordship. They had preferred a special leave petition before the Supreme Court that was dismissed, and I have produced a judgment, Lordship.
Why mention now?
Yes. Now, after that judgment was passed, they have come up with an application saying my suit should be dismissed because I will not be able to prove my case. So I had said before the earlier court that I do not wish to file an affidavit, let it be heard on. Lordship fixes a date for that purpose one because the suit is not proceeding. Otherwise, the judgment was passed in January, and thereafter they have filed this one after other applications have been filed. I do not wish to say anything about it right now, but Lordship will fix this is the substance of their application that I cannot prove my case. That is why this plaint should be dismissed.
Lord, I have
Whatever
not
it
taken
is.
Submission, Lord, when it will be
Yes,
heard,
yes.
Lordship will see the substance, Lord. That is his.
Yes, I would like to frame that
So
application.
you will not use affidavit.
No, I do not wish to. I'll.
The matter is to be fixed for hearing.
Yes. In fact, I thought my learned friend will be ready to begin his arguments, but as As usual, he is not.
Senses and suffering for the plaintiff, senses and suffering for the defendant.
I'm appearing for the state lordship. Mr. Sinha is there.
Yes, yes.
Yes, yes.
Yes, yes. Full team.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The defendant,
State.
defendant, the state of West Bengal has filed an application being GA Com 14 of 2015,
Last.
praying for summary dismissal of the suit filed by the plaintiff. Counsel for the plaintiff submitted he will not use any affidavit, and he prays for fixing the matter for hearing. In view of the submission made by the counsel for the plaintiff, let the matter appear on commercial hai na?
Lordship, 2 minutes it will take. I'll take 2 minutes. Only place the judgment. He will take. He will take 2 years. He can take 2 years, 20 years.
Okay, no problem, no problem.
Yes.
I will let the matter appear on.
Well, I think he's very angry, my lord. He had to-
Absolutely,
he had to
absolutely.
come to court, my lord, on
No,
when
no, no,
nobody else has come. So I think
I like the audacity. I like the audacity. After the Supreme Court passes the judgment,
Sometimes it's happened. Plaintiff's curiosity to dispose
Yes.
of the matter with the defendant.
The matter
Sana Joseph Dixon.
Okay, let the matter appear on. आज कितना तारीख है 16 29th April
28th April.
28th April
At some time, Lordship. At some time.
then it will be difficult.
Any date with the time, Lordship. I'll because we'll then finish. Any day with the time, Lordship.
My lord, may I request one thing, my lord? Subject to Lordship's pleasure. May it be any day in the first week of May, my lord, with the time also.
No, short for now, second.
হবে না?
I mean, first week বেশ ঠিক আছে।
First
আমি-
week May
হ্যাঁ,
বলছি।
but
যা
se-
বলছে শুনে
First
নিচ্ছি। হ্যাঁ, যা বলছে।
fifth, sixth আমি নেই খালি ওই দুটো
হ্যাঁ।
বাদ দিন বাদ দিন।
Excepting fifth.
No,
Sixth
sixth, fifth and
May.
sixth, not ex-
Fourth
no,
May, 4th May.
3:45 में क्या hearing होगा 11:30 होगा
seventh में blood
6th May
नहीं हमें नहीं।
My lord, 6th May, Mr.
No,
Sinha
I'm not
has
here
come
for
with
personal reasons.
7th May
7th May, sir.
7th May 11:30
Highly obliged, Lordship.
My lord, now that the heat is over, my lord, something very interesting which, my lord, I think both of us would like to share. Now, this was from an order of your lordship, not
Yes, yes.
allowing amendment. Lord, we not preferred a specially petition. It was initially admitted, a stay was granted. And Lord, the bench, Lord, was completely with the statement. We have the recordings to show. Lord, they were not being allowed to not even argue. Lord, the hearing was concluded. Both of us filed the written notes of argument. And my lord, both
And
of
the
us were
message of
shocked
Mr. Sinha
that,
also.
no, the SLP was dismissed.
No, no, I'll tell you, Lordship, what happened. Yes, what is being said is absolutely correct. Yes, yes, I also communicate. Absolutely correct. Now what happened? They filed an application before the judgment was passed. Same application which has been filed right now. Exactly same application was filed. Another application. So what I did, I told my learned friend, there's a system in Supreme Court that I can produce that copy of the application in a soft copy and the judges will be able to see it. I produced that judgment. Immediately the judgment was passed on this way.
No, but without taking it. Lord, that's his understanding, but that was not even taken into consideration.
Highly-
2 3 both
Lordship, this is
3 is also
no, this is a different matter.
no 2 only
Lordship-
2 huh?
Sri Millet, I am there, Millet, for the defendant bank.
He, Lordship, recollects, this was that matter where Lordship were allowed that Section 8 application by the defendant after 48 orders were passed, and therefore Supreme Court had stayed the order and directed the suit to continue, the hearing of the suit to continue. They came up with an application thereafter, after 48 orders have been passed, that this is not a commercial suit. Now, the Supreme Court direction was the suit to continue, no judgment to be passed. At that instant, Lordship had indicated that since Lordship cannot pass any judgment as directed by Supreme Court and the suit hearing to continue, they should get a clarification. This is 1 year back in 2024, April, if I'm not wrong. Now, they did file an application and they did come up and say before your Lordship that they are going to mention the matter. 1 year passed, nothing happens. Now, I want to like to proceed with the suit. The direction of the Supreme Court was
What has happened to the Supreme Court?
they have not done,
It's
they have
appearing
done
in the
nothing.
list, not the matter.
No,
Lordship,
the specific order was they will mention the matter and try to get their matter heard. Nothing has been done. We have not received anything.
my lord, the
I,
matter is
I am the plaintiff. I would like to get my matter heard. The Supreme Court direction was the suit to continue and the no judgment to be reserved.
Correct, that is correct.
my lord, the matter is appearing even my lord, in the Supreme Court, not even what the matter is appearing in the list, not even today.
Yes, yes. Appearing in the
But-
list does not mean
but
that it,
Item number 205, my lord, we it's not that not we are not taking steps, it's already in the list.
No, it's not on them. Let my learned friend say this. What is why he's saying? It is there in the list because civil appeals are taken on one day or in a week, and that is why all civil appeals are listed there. I think I know this better than my learned
I'm
friend.
sure he does.
Yes,
He has, I have no doubt not that he knows better about Supreme Court than I do.
Yes,
no
I
doubt in
have
my
to
mind.
go because
But
of
all,
this.
yes, all I'm saying that for these notifications, but the matter could not be taken up.
So I would like to proceed with my. Let them do whatever they want in the Supreme
What
Court.
is your application? What is the
Suit. The suit was for.
argument?
Yes.
The final argument?
Yes. It's an undefended suit. The certificate is already there. There are no written statement filed.
My
No
lord,
documents.
There
are
is
sought.
an interim
And
application.
I
I'm
would like
sorry,
to
my lord,
proceed
I
with
feel-
the arguments. My documents have been disclosed.
there-
Everything done.
Lord, Mr. Banerjee would like to make some.
Yes, Mr. Banerjee.
There is an interim application,
Yes.
pending, where my learned friend has correctly indicated. We say that this is not a commercial suit, but the disputes are not commercial in nature, as
Ah.
defined under that. So, this should be shifted to non-commercial bench.
So
Now,
that-
that application, while my lord had taken up, my learned friend has also indicated that my lord was of the view that if my lord today allows our application, that may tantamount to delivery of a judgment or a final decision in the suit.
Correct.
Which would be possibly not in tune or in consonance with the directions passed by the Honorable Supreme Court, which is why my lord wanted us to get a clarification. My lord, I am told we tried our level best, but there is a notification circulated which says that no hearing matter would be taken up excepting on Thursday or a particular day of
Not a
every
hearing
week.
matter is for application.
So suffering for the plaintiff, so suffering for the defendant. Counsel for the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The non-advocate appearing for the plaintiff submitted, being aggrieved with the order passed by this court under Section 8 of the Arbitration and Cancellation Act, the state has preferred
No, no, this bank, the bank.
The HDFC Bank, the defendant HDFC Bank has preferred an SLP, and the same is pending. But the Honorable Supreme Court is of the view that this court can proceed with the suit, but the final decision shall be abide by the result of the SLP.
No
Like-
judgment.
No judgment will be
No
delivered.
judgment.
No judgment can be delivered till the disposal of the appeal. Full stop. Counsel for the plaintiff submit that as the matter is ready for hearing and prays for fixing the matter for hearing. In view of the above, let the matter appear on 13th May.
Lordship.
13th May under the heading adjourn motion.
Lordship,
May the
any date
application
prior to
also
10th
appear,
May,
along with the
9th
suit.
May, 10th May, any date.
9, 10th is holiday. 9, 10, 11, 12 holiday.
Oh, acha. Eight,
May the
8th
application be also there in the list?
He doesn't like
But
that.
the application,
Counsel for this,
interlocutory
counsel for
application
the
will be pending.
defendant submitted, the defendant, there is an application being GA2,
No, my lord. It's GA5.
GA5,
GA6, my lord.
GA6 of 2021,
24.
2024, wherein the defendants of prayed for dismissal of the suit on the ground that the case is not in the nature of commercial dispute. In view of the above, let GS6 of 2024 be also placed along with the CS number 17.
Grateful to your lordship.
Lordship, 8th May possible if it's not.
CS
Priyanka, 8th May, I
CS
mean,
form
need it. Priyanka,
225 2024. 8th May.
He is
No,
not.
Mr.
May, Milord, I
Banerjee is
have some difficulty. Milord, I have some difficulty.
Come on, 13. Come on,
13th, if my learned friend Milord is not inconvenience, Milord, may we do it on 13th?
13th was there.
I need
13th.
13.
Oh, I thought he didn't like the
Lordship,
number.
some time be fixed, Lordship, because I like to.
13 तारीख क्या टाइम में होगा? 2 PM.
Yes, highly obliged.
13th at 2.
Grateful. Grateful.
Item number 4, I appear for the defendant number 1 to 4.
Yes. Why mention?
My lord, I have filed an application, my lord. It has also appeared.
My lord, may I
Yes,
copy?
sir.
of
I
the
appear in view of the
application?
defendant number 5, my lord.
It has been served.
Review application before the Supreme Court.
The reason for coming up with an application is that, my lord, there are 5 defendants. My lord, the defense was struck out. Defendant number 1 to 4, my lord, thereafter, my lord, the trial started, and by way of commission, my lord, the evidence was being recorded. In the meantime, my lord, the defendant number 1 to 4 preferred a SLP, which was allowed. My lord, the SLP was allowed in respect of defendant number 1 to 4. And they were allowed the liberty of filing the written statement. My lord, surprisingly, my lord, the defendant number 5 has not taken out any application. He has attended the trial. My lord, thereafter, in the department, they have filed their written statement. How can that be, my lord? Because his defense was struck out and he has taken no steps for making
I appear on behalf of
preferring
the
an
defendant number 5, my lord. My lord, I'd like to use a small affidavit in this regard, my lord.
my lord, that
What
cannot be. What
What
affidavit?
affidavit?
My lord,
I will place the orders
my
and
lord,
the
order,
records
my
in
lord,
the before the SLP, my lord. They did not appear. They did not file any affidavit. They did not prefer any appeal themselves. This is not an order in rem. This is an order in personam. They cannot take advantage of the order passed by the Supreme Court in favor of defendant number 1 to 4. Order eta bolto 98.
Yes.
My lordship will come to page 98 of the application I have filed.
Application का है? GA number? GA8?
J8, my lord.
Yes.
My lord, page 98, the order was passed by the Supreme Court will appear, my lord. If your lordship comes to page 99, in such view of the matter, the impugned order stands set aside. As a consequence, the application for extension of time to file written statement filed by the appellants before the High Court stands allowed. By the appellants, my lord, the order, both the defendant number 1 to 4 and the defendant number 5 had filed separate applications for extension of time to file written statement. By way of a single order, both the applications were dismissed. The defendant number 1 to 4 preferred the SLP. Defendant number 5 did not take any steps. My lord, this order allows the appellants only to file their written statement. How can they, behind the back, they did not come before this honorable court also, my lord, after the defense is struck out.
So, appellant before the Supreme Court is defendant 1 to 4.
1 to 4.
Not 5.
No, he was as arrayed as respondent number 2.
So, what application you filed now?
My lord, seeking redressal of this, they have gone to the department and filed their written statement. How can they do that?
My lord, if I'm allowed to
It is
submit, my lord.
accepted.
How the department has accepted, my lord, I don't know. Ray in the master summons, my lord, the written statement purportedly filed by the defendant number 5 in the department of this honorable court be rejected, returned, and not taken off the record. But they did not come before this court, did not take any steps, didn't even mention. And the Supreme Court's order, my lord, is very clear. Only the appellants were given the opportunity of filing their written statement.
Yes, how you file the written statement in the department, sir?
My lord,
When this court has disallowed the filing of the written statement, by which order?
My lord, lordship will give me 1 minute's time.
Lord,
Unacceptable. Lordship will come to page 44. This is the order passed 5th December 2023. Thereafter, my lord, we made an application for recording of evidence by way of commission. That started. All the defendants took part.
Dismissed. Conduct the defendant does not allow the sympathetic consideration. Prakash Corporate, GA4 and GA5 dismissed. Yes, then So this is order dated
5th December 2023, page 49, last in the aforesaid circumstances, GA number 4 of
5th
2023
December 2023.
and GA number 5 of 2023 are dismissed. Two separate applications.
Correct. When you file the return statement in the department,
My lord, that is on. Let me just indicate, my lord. My lord, on 1st of April, my lord,
1st of April of
2025, my lord. My lord, by mistake, my lord, that should be 27th of March, my lord. 27th of March, 2025.
madam, it can't be. See, the return statement they have affirmed on 16 November 2023.
My lord, that was that was their ground in the application for extension.
That's the court has not allowed, so this
Yes.
cannot be taken into
That
consideration.
is my prayer in the application, my
Not
lord.
necessary.
My lord, the department has accepted the written
Not
statement.
accepted. That's why I'm asking. Because
My lord, your lordship will pass an order in
That's right,
allowing my prayer.
that's why I have gone through the return
Yes.
statement. The return statement was affirmed on 16th November 2023.
Yes.
And it is filed on 16 November 2023. But they filed, it is recorded that they filed Wakalatnam on 27 March 2025.
My lord, whatever it is.
And this court has not allowed the return statement 5th of December. So this has
Yes.
not been accepted by the court.
My lord, my instructions are that my advocate on record went to the department and found out that the department has accepted the written statement of defendant number 5. That is the reason why I had to come up with this application, because your
Yes.
first order
What is
for
the
that.
contention?
My lord,
There is
so-
an order passed by your lordship, my lord. Lordship will allow me one moment, my lord. Where they have appeared and said that they have filed the written statement.
By which order?
my lord, that is on 28th of March 2025. They were also annexed, my lord. Page 107 of this application.
Lordship will come to page 107.
Counsel for defendant. Acha, last date. Yes.
And they come up before your lordship and say that they have filed their written
Okay.
statement.
My lord, kindly grant me a short opportunity, my lord, to deal with the allegations so far as my right not to
there's
file
no
the written statement, my
allegation.
lord.
So
My lord,
suffering for the plaintiff. So suffering for the defendant. Full stop. The plaintiff has filed the present application being GA-Com 8 of 2025. Praying for the written statement purportedly filed by the defendant number 5 in the department of this court be rejected / written / not to be taken on record.
I'm deeply obliged.
Full stop. Full stop. It is fine from the record. The defendant number 1241 PO24 and defendant number 5 have filed two separate applications, being GA4 of 2023 and GA5 of 2023, praying for extension of time to file return statement. This court, after hearing the parties by an order dated 5th of December 2023, dismissed both the application and not allowed the defendant to file return and not extended the time to file return statement by the defendants and had not extended the time to file return statement as prayed for by the defendants. being agreed with the order passed by this court in GA that is only with regard to the GA4 SLP,
Yes, please.
being agreed with the order passed by this court dated 5th of December 2023, the defendant number 121TO24 have filed an SLP before the Honorable Supreme Court, being special leave appeal number, special leave to appeal within bracket C numbers 11849 of 2024 against the order dated 5th of December 2023 passed in GA number 4 of 2023 within bracket Messrs. Gaurav Enterprises and others versus DOSCO within bracket India Private Limited. Full stop. The Honorable Supreme Court by an order dated 16th of December 2024 set aside the order passed by this court dated 5th of December 2023 in GA4 of 2024. क्या बोला? GA4 of 2023 and allowed the extension of time to file written statement to the appellants, that is the defendant number 1TO24. The counsel for the plaintiff contend that the advocate on record of the plaintiff, after scrutiny of the record, find that after the order passed by the Honorable Supreme Court, the matter was placed by the department before this court on 28th of March 2025. On 28th of March 2025, the counsel for the defendant number 124 and the defendant number 5 have submitted before this court that they have filed the written statement. Full stop. After the order passed by this court dated 28th of March 2025, the advocate on record of the plaintiff has verified the record of this case from the department and found that in spite of a rejection of the application filed by the defendant number 5, wherein this court has not granted and not extended the time to file written statement, but the written statement is on record. Written statement filed by the defendant number 5 is on record. Accordingly, the plaintiff has filed the present application.
The written statement was also served upon the plaintiff on 1st of April 2025.
The counsel for the plaintiff further submit that the written statement filed by the defendant number 5 is also served upon the counsel for advocate on record of the counsel for the plaintiff on 1st of April 2028. Per contra, learned advocate appearing for the defendant number 5 submit that the Honorable Supreme Court has set aside the order dated 16th of December 2024, and accordingly the defendant number 5 has filed the written statement and has served the copy to the learned counsel for the plaintiff, and he prays for acceptance of the written statement. Heard the learned counsel for the respective parties. This court find that initially all the defendant number 1 to 5 failed to file the written statement within the prescribed period, and accordingly they filed an application for extension of time. But this court has dismissed both the applications. Full stop. The defendant number 5 did not choose to file any SLP against the order passed by this court, but the defendant number 1 to 4 have filed an SLP, and the SLP was allowed, and the order passed by this court was set aside, and defendants number 1 to 4 have been allowed to file the written statement. Full stop. Taking the advantage of the order passed by the Honorable Supreme Court, though the defendant number 5 has not filed any SLP has filed the written statement. This court has considered the written statement filed by the defendant number 5, wherein it is found that the defendant number 5 has filed the written statement on affirmed the written statement on 16th of November 2023, and the same was also filed on 16th of November 2023 in the department. Subsequent to filing of the said written statement, this court by an order dated 5th of December 2025 has not, 2023 has not extended the time to file return statement. But
Copy
the written
filing
statement is
date
still in record. In view of the above, this court find that once this court has already has passed an order by not allowing not extending the time to file return statement, and the
দেখুন,
defendant
investment
number
আছে,
5 has not
register টাতে
referred any appeal against the
না
said
দেখে কি
order.
করবো?
Thus,
দেখে
the
নিই।
order passed by this court dated 5th of December 2023 in GA 5 of 2023 is attained its finality. Thus, the defendant number 5 has no right to file return statement. Accordingly, the return statement filed by the defendant number 5 is not accepted. The department is directed to return the return statement to the plaintiff within a week, to the defendant number 5 within a week from date.
My lord, may I indicate a small correction, my lord? Perhaps the date of the order passed by the
16
Supreme
December.
Court in the, no, my lord, it is 14 February 2025. My lord, page 99.
अच्छा 14 ऊपर है ना सुप्रीम कोर्ट का 16
I am
दिसंबर
deeply
को है ना,
obliged to you.
हो जाएगा में 14 फरवरी को 14 GA 8 JCOM 8 of 2025 disposed of. Gratefully.
Deeply obliged.
This is my claim.
Yes.
There are two defects has been detected. That in conscience statement and after uploading the conscience statement and correction has been made. Necessary, I am paying necessary leave to correct the conscience statement. And another in page 12, paragraph 25. It would be 10 lakhs 50,000, but by mistake it has been written as 50,000. In other paragraph, it has been stated that the suit is above 10 lakhs.
Yes.
In conscience
So
statement,
if your suit is 50,000, how this court is
in-
having jurisdiction?
that is mistakenly written. In paragraph 21, it has been written that it is above 10 lakhs.
What is the claim?
Paragraph 21.
Where is the claim?
Claim I have written
11 lakh. Principal amount 11 lakh.
11 lakhs. 11 lakhs 80,000.
11 lakh 80,000. So this should be
That correction should be 10 lakhs 50,000.
jurisdiction, the court fee, and the court fee is valued at rupees
Court fees I have earned.
10 lakh 60,000, 67,911.
My lord,
What would be the value?
value would be it can be given 10 lakhs 50,000.
Kindly come to the paragraph 25.
My lord, only 50,000 has been written.
Correct. So what is your value?
Value would be the claim and the amount of interest which would be assessed by the court. If it is not assessed, it cannot be determined. So I have given undertaking. Then after assessment, it will be paid.
And what about the court fee?
Court fee according to the value.
When you will pay the court fee? You are not paid the court fee.
No, not yet.
Then
Well, I have given undertaking that it will be paid after determination of the valuation.
Determination of the valuation.
Well, valuation depends on the dispute, claim, and the amount of interest.
When?
After the
At the time of judgment.
judgment,
At the time of judgment, you
or
will,
your lordship can direct me.
where from you learn that the court fee is to be determined at the time of judgment?
Well, I have read.
So if the court will dismiss the suit, you will not you will not give the court fee.
Well, I am correcting myself. Well, I have prayed for that as and when the honorable court will direct me. As and when the honorable court
So
will
that's why the court is putting a question when you will pay the court fee.
well, within 15 days.
First you pay the court fee, then I will pass an order. First you come with the court fee.
Well, then the correction.
Correction, first you purchase the court fee, then you come.
My lord.
So and so appearing for the plaintiff, the matter is listed as to be mentioned on receipt of the report from the department. It is found from the report that plaintiff has not paid the court fee. Accordingly, counsel for the plaintiff prays for 15 days time to pay the court fee. Let the matter be adjourned for 15 days. After the payment of the court fee, let the matter placed before this court.
And 7 also same defect. 7 item 7.
7 also same defect.
Same defect, same order.
Okay. 7 also same order.
That will be order.
I'm appearing for the plaintiff.
Yes.
But certain corrections are required, my lord.
Typographical error, verification, affidavit, statement of truth.
Yes, ma'am.
Pages number so and so are to be punched.
But in the prayer portion, my lord, in the
Hmm.
prayer portion, my lord, the quantum of claim, my lord, has been mentioned in para 13, but it has been written as para 12, prayer A, and both in concise statement.
Para A. Prayer A.
Prayer A, my lord. It has been written as 12. It
So
will
you already corrected.
But they have said that I need to take leave, my lord, and one more.
First you are corrected, then you want leave.
But one more thing is required, my lord. In the verification page, my lord, I have not verified the cause title, and my lord, the paragraphs mentioned, my lord, as true to my knowledge, my lord. Those.
So
need some
I am allowing to re-verify and reaffirm the affidavit and to rectify the defects and in regard to this amendment. These are the 3 things. You paid the court fee?
Yes.
Without court fee?
No,
When you paid the court
with court fee, I have filed it with court fee.
Since suffering for the plaintiff, the matter is listed as to be mentioned on receipt of the report of the Office of the London Master. It is found from the report that during the scrutiny, some defects have been pointed out. Accordingly, counsel for the plaintiff prays for rectify the defects within 2 weeks. Within 2 weeks. Counsel for the plaintiff prays for leave to correct to delete the numerical 12 in prayer A of the plaint and to add the numerical 13. Counsel for the plaintiff also prayed for leave to re-verify and reaffirmation of the affidavit. In view of the submission made by the counsel for the plaintiff is directed to cure the defects within a period of 2 weeks from date. After curing the defect, the plaintiff is directed to re-verify and reaffirm the verification and the affidavit within a week thereafter. The plaintiff is given liberty to correct the paragraph number in prayer A as paragraph 13 instead of paragraph 12.
But in the concise statement as well.
As well as in the concise statement.
And the verification paragraphs required to be changed in statement of truth as well.
That's why the re-verify you will correct.
Great.
Lordship, I appeal
Yes.
for the judgment letter number 2.
Got the check. Paid the amount.
Yes, your Lordship, this is the demand draft.
How much? How much? What is the amount?
34.
The decretal amount, your lordship.
Decretal amount.
কত?
34 lakhs.
My lord, the decree was 34 lakhs principal along with interest at a particular rate from ক্যালকুলেশনটা কোথায় আছে আমাকে একটু দে ক্যালকুলেশনটা $34 lakh is not the decretal amount.
Where is the prayer?
দে
With 12% interest per annum.
Where is the
Well,
order?
that interest comes to 38,76,000.
Where is the appellate court order? What the appellate court says?
Appellate court has.
Decretal amount. The appellate court's order was decretal amount. The entire decretal amount has to be secured.
I'm grateful to my learned friend.
Your lordship,
Page 40 of my application.
Lordship, I have also filed an application to secure this
the
decretal
order
amount
passed
before the
by-
appellate court, your lordship. So I'm
Your
humbly
lordship.
praying that your lordship kindly stays this.
It is very clear, my lord. The decretal amount.
To pay 34 lakh along with interest.
Yes, my lord.
Under the appellant is, yes, along with the interest.
But they're aware of it every time. They're just.
The rate of 12% per
This
annum
is the
January
practice.
till realization of the amount. So till the amount is
According to your calculation,
your lordship, if I may direct your attention to the order, I appear for judgment data number 2. In our order, your lordship.
one. You are for one, Mr. Harsh.
I'm for 1, your lordship. In our order where the appellate court has allowed us or granted us the stay, the appellate court had directed in the order dated February 12, security amount. Your
Yes, my
lordship,
lord, that is the security amount.
correct.
The
Because
decretal amount is 34 lakhs
Whatever,
along with
I
interest.
bow down before your lordship. I bow down. Whatever your lordship deems fit, your lordship will order.
because
I shall do
1st
the need.
September 2024, the appeal was admitted with the condition that the appellant is directed to pay rupees 34 lakh along with interest at the rate of 12% per annum from 7 January 16 till the realization of the settlement. Till the realization is till the amount which you have been deposited now. So
your lordship, that was for KNH, the judgment
No,
data
no, no.
number.
My lord, what is
Our
food
order
for the
was
goose
passed.
is food for the gander
Absolutely,
also.
absolutely. I'm grateful to my learned friend.
He is not a privileged
Yes.
litigant that he will have a different.
So there cannot be two different orders. You will not
I
give-
apologize, your lordship. I was
Grateful to my
referring to
learned
the
friend.
stay order that the appellate court has filed. We filed the appeal in which, your lordship, we've also filed another application for stay, which was to be listed today. However, because of the change of the bench, your lordship, the
Lordship,
matter
our
will now be
application
listed.
was also to be listed before the
Today the
appellate
bench
court.
is available. They have not mentioned.
We have filed the application, your lordship, to furnish the
It
decretal
is
amount.
just a
No, no,
tactics
no,
of
no.
delay,
It
my
has
lord.
been filed,
The
your
first-
lordship. It is not appearing before their lordships.
So this is the total amount, 34 lakh is the principal amount.
Yes, your
It's-
lordship.
no, no,
Yes.
no.
Yes, this is the decretal amount.
Principal amount of 34. The decretal amount is 34 lakhs along with interest at the rate of
No,
12.
that's why 34 is the principal.
Yes, your
then the
lordship.
Yes.
decretal is
Yes,
12%
your
per
lordship.
annum. Correct.
Page 44, the drawn up decree is at page 44.
Page 44, your lordship will come to page 44.
Starts at 42 and 40.
$34 lakhs with the interest at the rate of 12%. Defendants do jointly and severally pay sum of rupees. So 34 lakhs. So how soon you will give the interest?
My lord,
Your lordship, it will take time since my
Lordship will
clients are in
allow
Delhi.
me-
My clients are in
lordship.
Delhi. It will take time, your lordship. Whatever falls from your lordship, I bow down
My
before.
lord, one submission, my lord. The decree was passed. They preferred an appeal. In September 2024, the court had directed them to put in the security. We are on 16th of April 2025.
Lordship,
More than 7 months, every time they are coming before this court and asking for extension.
I would humbly
My lord,
beseech your lordship to let bygones be bygones, your lordship.
And their application for second application for extension of time to put in the security, my lord, that has been dismissed by the appeal court.
Your lordship, we have
defendant
filed
number
an
two is
application. That application will appear before the appellate
The
court
third
tomorrow.
application on their part.
We
but
have,
the
we
first
have filed the application. There was
Well-
a difficulty, your lordship. There was a bereavement in the family of my advocate on record.
Please. The bereavement was sometimes in November.
It was a very tragic
on
one.
that ground,
okay,
extension
okay.
was
Okay, you tell me when
Your
you
lordship,
will-
my clients are in Delhi, so I will
just
need
the
some
delayed
time.
access.
I will need some
But
time.
this
your
is the submission every time they come before this court.
Why will I do that, your lordship? If I have
Bunch of
submitted
orders have been
this,
passed.
I can submit.
Order gulo dekha.
I can, if I have before your lordship placed
lordship
that
will come
DD
to
of
page
34 lakhs,
64.
I can very well pay the interest amount also, your lordship.
Correct,
Whatever
correct.
falls from your
Why
lordship.
don't they
I
pay?
bow down.
That's why this court is asking you.
Yes,
how soon you will give the interest amount, you will pay the interest amount. Tell the date.
Your lordship, if your lordship grants us a week's time, your lordship, because
At
my
least
clients
5
are in
times
Delhi.
they have sought for
My
extension.
clients are in Delhi, your lordship.
No,
No, your lordship.
but they-
No,
they
your lordship.
filed
Your
an
lordship. Your
affidavit of
lordship will not
assets.
do that. Lordship,
If
I'm
you not,
humbly.
I will pass the conditional order by today. We are on
Your lordship,
Lordship, there are holidays in
by
between.
24th. You will not disclose. You will not give the interest amount till the 11th of April 2025. Then I will pass an order for affidavit of assets on
My
20.
lordship will pass that
lordship-
order today.
Your
in
lordship,
before-
I'm getting only 4 days time. My clients are in Delhi.
My-
There are holidays in between. I am praying, humbly
Interest
praying
on
for
bank. They
21st.
were fully aware of
Humbly
that.
praying for 21st of April.
Your
Humbly
lordship-
praying, lordship.
Lordship
Humbly
will consider
beseeching your
one
lordship.
thing, my lord.
Humbly beseeching for 21st of April.
20, I am giving a 24.
No, your lordship. Sorry, I'm sorry. 28th. I meant 28th, your lordship. That was a slip of tongue.
Lordship will consider only one thing. They were aware that they would
Very
have to-
well. I
Let me
agree.
complete my
Just-
submission,
Just let one advocate complete the submission. Then I will hear.
They were aware that they would have to pay this amount at the time of passing of the decree. My lord, they preferred an appeal. An order was passed in September 2024. They were aware that they would have to pay the entire amount. I am not speaking about the defendant number 1. The defendant number 2 was aware. Thereafter, they had taken several extensions. Today, they come up with only 34 lakhs. But this is deliberate.
Your lordship, this is not deliberate. I bow down before your lordship. I am humbly beseeching to your lordship. Give me time till 28th. There are holidays in between. My clients are in Delhi. Your lordship.
Judgment chapter number 2. Since appearing for the caveat. So counsel for the judgment chapter number 2 has handed over a copy of the demand draft number 131233 of Standard Chartered Bank. Which branch? In Central Mumbai branch, dated 11th April 2025, for a total sum of rupees
On 11/20/25, they are making a demand draft, being fully aware that they will have to pay something else.
That's why I'm passing on. Let's hear. Of rupees 34 lakhs. Full list.
If I had no
Name
intention to pay, I
Name
would not
of the
do this.
registrar, comma, original site, High Court of Calcutta. Full list. So your deposit is submitted before the registrar. Where is the letter? Have you submitted this?
It's submitted.
Where is the letter?
No, your lordship.
So this is a copy. Where is the letter?
No, that is the original, your lordship.
It is not the original, madam.
That is the original.
The online.
Key on.
It is not original.
This is the original, your lordship.
Mhm. It is not the original.
স্ট্যাম্প কোথায়? এটা তো জেরক্স করে
Xerox or online copy? It is Xerox or online? It
Your
is
lordship,
submissions
your lordship, my instructions were that this is the demand draft, your lordship. I will
to a
seek further
Nikkei,
instructions.
it is,
Your
apparent that
lordship
this is
will,
not-
your lordship will kindly grant me time to furnish the entire amount along with the interest.
No, madam. Your client is playing with the court. It is
Your lordship,
obliged.
your lordship, kindly, your lordship,
obliged,
kindly allow me, your lordship. Kindly allow me, your
for
lordship.
making the court fool.
No,
giving
your-
the copy or online copy of the demand draft.
I,
You have not submitted the same to the registrar original side 11th of
Your
April, you
Lordship,
could have
there
been
were
submitted.
holidays.
There is a
between the-
procedure. There is a procedure in the High Court rules. How the amount is to be deposited.
Yes,
to
Your
the
Lordship,
registrar.
entire
This was-
procedure will be
this-
followed.
Where is that?
Entire, Your Lordship, there were holidays in between.
My
Today
lord,
it shall
the
be done, Your
holidays-
Lordship.
This was fixed
Yes.
prior to the holidays on
You'll-
10th of
you'll-
April.
This court has fixed the on
Yes, Your
11th.
Lordship, my
No,
client.
no, this court was fixed the matter on in 10th.
Yes, Your Lordship,
Yes,
my
this
client.
matter could have
My
been taken up
clients
on
came
that
from
day.
Delhi, Your Lordship. They have,
Unfortunately, court was not here.
your clients came from Delhi, Your Lordship. They facilitated the entire thing, Your Lordship. They had visited
So
the
I am
office
taking
of
at
my.
3 p.m. You deposit it. Otherwise, I will see to that.
Yes, Your
Let the
Lordship.
matter come at 3 p.m.
Yes, Your Lordship. I'm grateful.
Come with the report of the registrar original side that this has been deposited.
I'm grateful. I'm grateful.
Deeply obliged, Your Lordship.
I am for the petition.
Lordship.
My contempt
Yeah,
application on the
contempt.
last occasion.
ये कंपनी है 345 बोल रहा हूँ come at 345 345
I am appearing for the
yes
On the last occasion, Your Lordship, there was a direction to file.
with leave to my learned friend.
No, no, bolu no, bolu.
Last occasion, Your Lordship directed me to file my affidavit within 3 weeks.
Hmm.
Lord, I'm praying unconditional apology due to my maxillary treatment. It is delayed and it has been affirmed and it has served a copy to my learned friend. Lord, so Your Lordship can take trouble to Your Lordships. Lord, this is my humble submission. No, madam.
Let me come back here. Then I don't know, Your Lordship. Right now, he has given me the copy of the affidavit. Lordship, next week, Your Lordship, kindly see.
Any
how
day,
many
Your Lordship.
sole contempt now
Contempt, but he has given me only one
you
affidavit.
are appearing for whom
1 and 2, Lordship.
so your joint affidavit
Why not? Though?
in the contempt application
Lord, in that event, my Lord, sorry to my Lord, we have make it my Lord,
what is going
Separate
on
separate copy. Okay, Lordship.
Huh?
My Lord, it is my mistake on my part. Lordship, don't take by the way, Lordship. I will do it, Lordship. Same
So-
contention to be,
so when you will file
my Lord, within 3 days. Because, my Lord, because next working day is a 1 day.
so how many contempts are there
Two contemners, Your Lordship. He is representing two contemners.
only two
Yes, Your Lordship. He is representing two.
sense appearing for the plaintiff sense appearing for the content number 1 and 2 Learned counsel appearing for the content number 1 and 2 has filed affidavit of affidavit in opposition joint affidavit in opposition of content number 1 and 2 Full stop. This court has not accepted the same accordingly the contenders are directed to file their separate affidavit within a period of 3 weeks 3 days from date
Or for 3 or 4 days, my Lord, because in the meantime, all holidays, Your Lordship.
by 24th of by 24th of
So kind of Lordship.
April 2025
With copy to my learned
after
friend.
serving copy to the learned counsel for the
no.
plaintiff leaves the matter on 25th of April.
So on the last occasion, Your Lordship directed the defendant number 3 to appear. Lordship, the same prayer.
Not there.
He is not there, but I will again serve Your Lordship. Your Lordship only
Come
directs.
on that day we'll see to that.
Lordship. In the meantime, again I'll.
Though by an order dated 7th of March 2025 this
Last
court
paragraph.
directed the defendant number 3 to appear before this court in person but neither the defendant number 3 is appeared in person nor represented by any person. Accordingly, the defendant number 3 is directed to appear before this court on 25th April 2025. Police, the plaintiff is directed to take appropriate steps to issue notice upon the defendant number 5 for his appearance. Content number 3 for his personal appearance.
Lordship.
Written there.
My Lord, should I take that?
Yes, please.
So kind of
Okay.
Yes.
My application, madam.
But I'm appealing for the alleged
Maybe have a look at
contempt.
your lordship's last order.
Have you
Yeah.
deposited?
But may I just indicate, my lord?
12 lakh you have deposited
my lord,
on 11th.
May I just hand over a copy of the affidavit, my lord?
Ah.
27 lakhs out of 40 lakhs, my lord, is already with us. I have a copy of the demand draft and the original fixed deposit certificate, my lord, will permit me. the original demand draft kindly permits me leave, my lord, to deposit the same with the registrar, my lord, original side. And the balance amount, paragraph 6 and 7, my lord, I have indicated that by end of this month, we'll tender that as well, my lord.
Yes.
Well, may I say this? Let them submit the demand draft and the fixed deposit. The demand draft will have to be is in the name of then the registrar will there will have to be direction on the registrar to encash this and invest this in a fixed deposit. So far as the original fixed deposit is concerned, there will have to be an injunction on the encashment of this fixed deposit.
So why you deposited in the district cooperative bank?
I have not.
That 11th February.
But this was done previously, my lord.
No, previously 11th February 2025.
Lord, before this contempt application was contempted
you
to
had
remove,
this order.
When you received the contempt application?
I'll just indicate the date, my lord.
7?
Contempt application serve
This is they have got this in April, the contempt application, but the order was passed originally on 30th August 2024.
This is just
They had committed that they would comply on, and that is recorded in orders dated 26th November 2024 and 7th January 2025.
You had the knowledge, then instead of paying the amount, you deposited it. I am directing this is to be in cash and deposited in the name of the registrar.
Kindly direct the branch manager of the bank to remit it.
I am not believing with regard to the cooperative bank.
Yes.
This cooperative bank is very dangerous.
That is also an issue, yes. Let them
if your lordship will recall, my lord, last week also this matter was taken up where we indicated certain inabilities.
Now I find this. I thought it is the old one. It is a February 2025.
But this was just to, my lord, initially show our bona fide, my lord, that whatever amount was available with us, my lord, we deposited with the district cooperative bank, my lord, earmarked in a separate fixed deposit. We'll give it before the registrar, my lord. I've stated so in my affidavit as well.
So many cases I dealt with the district cooperative bank with regard to the payment and all these things. How the district cooperative bank works, we know.
In cash demand draft
But in any nationalized bank, that this court can accept. But the district cooperative bank, it is very difficult. You will made a publication, lost. One chairman will change. Chairman will come and sign and disburse.
Lordship may record my undertaking, my lord, that
we will FD and make into a demand draft in the name of the registrar and submit it. Lordship will keep this in the first week of May. They have said they'll comply with the entire order by end of April. The demand draft they have brought in the name of the registrar original side may be deposited today. And the balance they may secure by the end of the month.
So this is 15 lakh. What about the other?
But this we have stated, my lord, by end of this month will kindly grant us, my lord, time, my lord, 13 lakhs by end of this month. Kindly seize, my lord, paragraph 7 of my affidavit.
Now it will be more.
Last time you have undertaking, 11th April, you will give the 12 lakhs. And by end of April, 13 lakhs.
So the 12 lakhs, my lord, demand draft is there, my lord.
Demand draft is there?
Yes.
What is the date of the demand draft?
9th of April 2020.
Okay. So what 13 lakh will be by end of April?
By end of April. There is just the inability, my lord. The intention is to comply with your lordship's order, my lord. Kindly gives me that time, my lord.
Sensation suffering for the petitioner. Sensation suffering for the alleged contempt. The petitioner has filed the affidavit of service. Let the same look at the record. The alleged contempt has filed affidavit along with a Xerox copy of fixed deposit under reinvestment plan receipt number 728 of District Cooperative Bank Limited in connection with account number 001201400003685 of District Cooperative Bank Limited, Head Office Varanasi, for a total sum of rupees 15 lakhs, which was deposited on 11th February 2025 and maturity date is 11th February 2026 and the maturity amount of is rupees 116,09,369 in the name of Prabha Infrastructure Private Limited. Full stop. Counsel for the alleged contemner submit that the alleged contemner has also made the demand draft in the name of registrar original side of this court, being demand draft number 404021 dated 9th April 2025 for an amount of rupees 12 lakh of Punjab National Bank, Varanasi branch, Uttar Pradesh. Full stop. Counsel for the plaintiff submit that the alleged contemner will deposit the original fixed deposit under reinvestment plan receipt number 728 of District Cooperative Bank Limited for an amount of 15 lakhs in the name of Prabha Infrastructure Private Limited, as well as the demand draft of rupees 12 lakhs in the name of Registrar Original Site of the High Court at Calcutta of Punjab National Bank, Varanasi branch, Uttar Pradesh. And the remaining amount of rupees 13 lakh shall be deposited by the alleged contemner by the end of April 2025. In view of the submission made by the counsel for the alleged contemner, the alleged contemner is directed to immediately surrender, immediately deposit the fixed deposit under the investment plan receipt number 728 of District Cooperative Bank Limited dated 11th February 2025 for an amount of 15 lakhs along with the demand draft of rupees 12 lakhs of the Punjab National Bank, Varanasi branch, Uttar Pradesh to the registrar of this court by today, by tomorrow. That is by 17th of April 2025. Full stop. The registrar original site is directed to keep the original fixed deposit under the investment plan receipt number 728 of the District Cooperative Bank Limited dated 11th February 2025 for an amount of 15 lakhs in the safe custody and with regard to the demand draft amount of rupees 12 lakh shall be encashed and reinvested in the interest bearing fixed deposit receipt of any nationalized bank with auto renewal facilities till the disposal of the contempt application.
There should be an injunction on them not to
pull it up. The alleged contemner is directed to deposit until further order. The alleged contemner is also directed to deposit the remaining amount of rupees 13 lakhs with the registrar on or before 30th April 2025. On receipt of the said amount of rupees of 13 lakhs, the registrar original side of this court shall also invest the said amount in a fixed deposit interest bearing fixed deposit receipt with auto renewal facilities until further order. Full stop. As the alleged contemner has deposited the original fixed deposit under the reinvestment plan receipt number 728 of the District Cooperative Bank Limited, Varanasi, in connection with account number 00120140000683685 dated 11th February 2025 in the name of Prava Infrastructure Private Limited for an amount of 15 lakh as security in the present case. Accordingly, the branch manager / secretary or any of the computer who is the authority?
Branch manager, madam. It's the
Branch manager / secretary of the district and the chairman of the district cooperative bank limited Varanasi is directed not to encash the fixed deposit amount of rupees 15 lakhs along with the matured amount without the leave of this court.
And to keep the FD renewed.
And the fixed deposit slip, fixed deposit under reinvestment plan receipt number 728 be kept as a lien until further order of this court. Let the matter appear on 5th of May 2020. Yes. Yeah, witness action.
Lordship, I have
Appearing?
no, my lord. Lordship will give me a minute's time. I want to make a submission. My lord, your lordship will recall there are two suits. The first suit, evidence was being recorded, and there was an order while the evidence was being recorded. My lord, my learned friends had made an application for disclosure of fresh documents after the evidence of their first witness was over. My lord, that application was heard, and the order was awaited till October 2023 till March 2025, my lord.
By this court?
No, by the other
Okay,
coordinate bench, my lord. Now, my lord, the first suit is on repudiation of a claim in insurance claim. The second suit, my lord, is related to the first suit in the fact that, my lord, the second repudiation was based on the first repudiation. My lord, ideally, we wanted to complete the first suit. Whatever is the result in the first. The first suit, my lord, I have come up with a fresh application for extension of time of the mandate of the commissioner because the witness action of the plaintiff is over. My learned friend has 3 witnesses. 1 witness is complete. The other 2 witnesses are pending. My lord, the application is appearing before your lordship as item number 23 in today's list, my lord. In the first suit, my lord. My lord, I was praying that the commissioner's mandate may be extended. It has expired on 31st of December 2023. 2023 or 24? 23.
23 December.
December 2023, 31st December 2023, the mandate of the commissioner had expired during the pendency of that order from in that application made by my learned friend.
What application they have?
But they had made an application for disclosure of further documents, which.
So that is allowed.
No, my lord, that has been disallowed. Now, my lord, I have come up with an application before your lordship, my lord, praying for extension of time to file time of the commissioner, and there are two other witnesses. My lord, directions may be given for completion of that evidence, my lord. That will shorten the process in the second suit. My lord, this submission was made by my learned junior at the time when your lordship was giving direction for affidavits in the second suit, my lord. I will humbly pray, my lord, that will save a lot of time of judicial time of this court. So, my lord, this suit may be kept at abeyance for the time being. and let the first suit be heard out and completed first.
They don't want to proceed with the second suit, Your Lordship. It's their choice.
No, we are ready with the affidavit, my lord.
If I win in my first suit, the second
This
suit
one.
goes.
Either way, my lord, if I get a decree in the first.
Why both the suit has not been taken with the commissioner?
My lord,
Analogously.
Stage was different, my lord.
That is the problem.
Second suit was subsequent, my lord.
So you want this it is to be synodi?
No.
Proposal.
Out of the list for the time being, made with liberty to mention. We'll come back before your lordship, my lord. Let there are two.
With the what is the stage of that suit?
That suit, my lord,
witness is
the plaintiff's evidence is over. The defendant has three witnesses, out of which the first witness is complete. The second one, while at the time of filing the affidavit for the second witness, my lord, they made this application for disclosure of further documents which were in their custody. My lord, that has been disallowed. Now, your lordship will give them directions to file their affidavits of evidence, and we'll give directions for expeditious.
Item number 23.
23, my lord.
Item number 23.
রাতুল কোথায়? সর্বত অনলাইন।
Where A and
No
B.
problem. So I am extending that time.
Yes, sir.
You file the examination second witness.
Yes, sir. Second witness will
First
do it.
witness is over.
First
My lord,
witness is over. Second witness
only
will do
prayer,
it.
my lord.
The third witness, Your Lordship, is CFSL. So I have to, Your Lordship, take out the application for
Subpoena.
So that cannot be done before the Your Lordship, the learned commissioner. I'll take out
That's
that.
why if that is over, then come
My lord,
here.
let my learned friends take steps for that as well, expeditious steps, my lord. For no
That's
fault
why
of ours, we have been
Immediately after
suffering.
completion, you
Yes, yes.
come here.
We'll take out an
That the matter will be taken here, and because CFSL, you want to send the document, or you will you
have
are
to-
having the report and you want to examine
The report has to be the report is
report
already
is
on
there.
record.
only you want to examine the
Yes,
expert. You want to examine the expert.
Yes.
But that can also be done by way of commission, my lord.
No problem. If they are agreeable, Your Lordship, I will.
But only thing, it has to be done expeditiously.
That can be.
My lord, we have lost a lot of time. The plaintiff is suffering.
Suffering for the plaintiff. देना ये जो order करती है item number, which item, this one?
Item
No,
20.
this 14 no? So suffering for the plaintiff, suffering for the defendant. The matter is fixed today for witness action, but the
Lordship, may I make a small submission? I had a talk with my learned friend, my lord. If your lordship passes an order today itself in respect of CFSL also, my learned friend will be able to take steps for
But
making
the
arrangements.
I don't have any problem if Your Lordship passes an order, because unless and until Your Lordship, this direction is gone from the
Government
court,
offices, my lord, they will not take
CFSL will
it.
not come.
Yes.
So that
now
they are
what I
clear.
propose, let first witness, second witness be examined. Immediately after the examination, you mention it so that the court can issue
No
the
problem.
suffering.
We'll do it.
That will be better because we don't know.
My lord, the
It's
only
today.
thing, the paraphernalia of issuing, asking them to come.
What would be the date of the issuance of the suffering? Which CFSL?
Your lordship will provide that in the order itself.
One CFSL, Your Lordship, and now they have shifted, Your Lordship, from
No, that's why they have
CIT
only
road to-
Calcutta.
Yes, yes.
Calcutta, this one, Newtown now.
Newtown, Your Lordship. They have opened a new office.
Your lordship can provide in the order itself immediately upon completion of the witness of the second
Okay.
witness.
So suffering for the fix for witness action. So the counsel for the plaintiff submit that the previous suit is pending, is at the stage of evidence, and plaintiff witness has been examined. Defendant one witness has also been examined, and the second witness of the defendant, second witness and the third witness are yet to be examined. And as I'm full stop, counsel for the plaintiff submit that the result of the first suit is depend upon, and result of the first suit is the result of second suit. Accordingly, counsel for the plaintiff submit that for the time being, the present suit may go out of the list till the completion of the evidence of the first suit. In view of the submission made by the counsel for the plaintiff, let the suit being CS Com 317 of 2024 within bracket old CS 197 of 2021 be placed and be go out of the list for the present, liberty to mention after notice to the parties. Okay. So we are now item number 23. So suffering for the plaintiff, so suffering for the defendant. The plaintiff has filed the present application being GA Com 6 of 2025, praying for
Who's the village?
issuance of commission, issuance of writ of commission, and praying for extension of time for examination of the defendant witness by commission. Police counsel for the plaintiff submitted, and defendant witness number 1 has been examined and cross-examined. Now the defendant intend to examine further 2 witnesses, including the expert, and prays for direction upon the commissioner to expedite the examination of the defendant's witness so that the matter can be expedited and disposed of as early as possible. In view of the submission made by the counsel for the plaintiff, time to complete the examination of the defendant's witness is extended. How much time it will take?
8 weeks, Your Lordship.
Today we are on May, which is the vacation.
Your Lordship, after 24th, there is a vacation again.
Is extended till today we are on April.
30th June, Your Lordship, it will complete it. Your Lordship.
Till 24th of June 2025, full stop. In the full stop, it is the full stop. The defendant is directed that immediately on completion of the examination of the defendant witness number 2, the defendant will take appropriate steps for issuance of subpoena for appearance of the expert witness before the commission. And if the expert witness will appear before the commissioner is requested not to adjourn the matter and to dispose of the and to continue the examination and cross-examination the expert witness if required on day-to-day basis.
Deeply obliged.
The commission is directed to file the report by 25th of June 2025.
I'm grateful.
My suit, praying for leave under clause 12. And
Yes.
my suit for recovery of money lent in advance, praying for leave under clause 12 and order to rule 3 of the Code of Civil Procedure.
Why order to rule 3?
Rule 3 is because there are 2 loans in question. This is by abundant caution. 2 loans in question. Initially, we had the plaintiff had disbursed one portion of the loan. Thereafter, the defendant approached for increase of the same loan, and a separate disbursement was made. By abundant caution, since all the acts are the cause of action arises out of the same series of acts of the defendant, but since there are 2 separate loans and I'm claiming under both the loans, I'm prayed for leave under order to rule 3 for joining those 2 causes of action. And leave under clause 12 is the defendant is situated outside. The plaintiff is within. The agreement was entered into within. The disbursement was also made from within the plaintiff's bank account. The money is also repayable at my bank account. Kindly takes my paragraph 20 of my plaint. Page 10.
Consensus suffering for the plaintiff. The plaintiff has filed the present suit praying for recovery of an amount of rupees 40,57,342 along with interest at the rate of 12% per annum. The plaintiff has prayed for leave under clause 12 of the latest patent, 1865 on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose out of the jurisdiction. The plaintiff has also prayed for leave under order to rule 3 of the Code of Civil Procedure on the ground that the claim of the plaintiff arose out of the same loan agreement which consists of an initial as well as enhanced loan. And for the abandoned caution, the plaintiff prays for leave under rule 2 of the Code of Civil Procedure. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the part cause of action arose within the jurisdiction of this court and part cause of action arose outside jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. This court is also find that the claim of the plaintiff is arises out of the same loan amount, which consists the initial as well as enhanced loan, and as such, leave under order to rule 3 of the CPC is granted. Rent is admitted subject to scrutiny by the department.
Grateful. Well, it's the similar sort of a suit, but I'm only praying for leave under clause 12 of the latest patent. There's only one loan. The plaintiff is the same. The defendant is different. The defendant is situated outside. The plaintiff is within.
When the last payment was made?
The last payment was made. Part payment.
21.
Yes, 2021.
Then?
Thereafter, there are confirmation of accounts till the financial year ending on 31st March 2022.
March 22.
Yes, March 2022. It's signed by the defendant. Lordship
when you filed the suit?
But the mediation was initiated in the meantime. The mediation was instituted in 2024. Page 33, if your Lordship sees, the report of the Mediation Council was forwarded on 6th March 2024.
Suffering for the plaintiff. The plaintiff has filed the present suit praying for a decree for a sum of rupees 1,12,15,476 along with interest at the rate of 9% per annum. The plaintiff has also prayed for leave under clause 12 of the latest patent 1865. At the learned counsel for the plaintiff peruse the readings. This court find that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the department.
Grateful.
Next.
Item 13, Your Lordship, may I present the plaintiff, Your Lordship. It's a suit for recovery of money. Your Lordship, the plaintiff, Your Lordship. The plaintiff, Your Lordship, is the Berger, Your Lordship, Berger. Office is in Park Street. Now, Your Lordship, the defendant approached them for the supply of, Your Lordship, the industrial pens. And thereafter, Your Lordship, we supplied. Invoices were issued from the, Your Lordship, the office from the Berger house. And thereafter, Your Lordship, all the materials were supplied to Haryana. Now, part payments made, there are certain, Your Lordship, invoices which are required to be paid. That has not been done. In a meeting in a Berger house, Your Lordship, they finally found, Your Lordship, that they are in financial constraint, and that's why, Your Lordship, they could not do it. But they have said, Your Lordship, that in Faridabad there is an immovable property. They'll sell out that particular property, and Your Lordship, they'll distribute, Your Lordship, among the creditors. In that particular meeting, Your Lordship, they said that there is a compromise settlement deed. On that basis, Your Lordship, I have to, Your Lordship, compromise it. It was not acceptable because that was 10% of the entire dues. Thereafter, Your Lordship, they have filed, Your Lordship, that particular compromise under section 230 of the before the company, national company. So I am praying for today, Your Lordship, clause 12 leave as well as section 12A because there is an apprehension, Your Lordship, that the only asset they'll sell it out.
Where?
That is in Faridabad, Your Lordship. Lordship, kindly take, Your Lordship, the email where from, Your Lordship, will see, Your Lordship, page number 141. 4th February 2025. Now you kindly see the place of the meeting, Berger House, 129 Park Street. Now, clause number 2. Mr. Ayush Maheshwari notified that the cause for delay in sale of the assets of the company owing to District Town Planner of Faridabad not issuing an NOC for the sale of the land. And that particular compromise, Your Lordship, was not acceptable to me. That is at clause number 5. Mr. Dasgupta expressed that the scheme is not acceptable to him and met with the legal department. And the unpaid invoices, I have given the list, Your Lordship, at page 108. Page 108, Your Lordship, is the list of unpaid invoices. And the invoices, Your Lordship, I have annexed, Your Lordship, from page 18 onwards. These all invoices, Your Lordship, issued from 29 Park Street. Simply, Lordship, this is suit for recovery of money, and Your Lordship, as on today, Your Lordship, there is an outstanding of around 1,60,721 that I have given in page 8, Your Lordship, of my page 8. I have given the particulars. Principal amount 1,01,060 and 18% interest, Your Lordship, till 31st of March. 1 crore.
When the last payment was made.
Yes, Your Lordship.
When the last payment was made.
The last payment made, Your Lordship, I have pleaded, Your Lordship. June 2024. Lordship, kindly see page 8. Paragraph 8, page 4, last 4 lines. Last of such payment was made in the month of June 2024 against earlier dues not forming part of the outstanding invoices which are the subject matter of the instant suit. And Your Lordship, all these invoices were issued sometime, Your Lordship, in 2024, page 108, 25th February 2024 onwards. So there is no question of limitation, Your Lordship, regarding the last payment, page 108. Page 108, Your Lordship, 4th column or 5th column, 25th of February 2024.
So what is the situation of the factory now?
Factory, Your Lordship, the factory is closed. At any point of time, they'll sell out the property. And I would be in, Your Lordship, that's the only assets of the company.
Where is the apprehension that they are going
Lordship,
to
I have shown, Your Lordship, that page 141, Lordship, kindly sees clause number 2. He himself is saying, Your Lordship, that he is in process of sale of the assets of the company in Faridabad. Page 141, clause 2.
Yes.
And page 142, there is another meeting in which also, Your Lordship, clause number 2, they are saying that they're in process of the sale of the assets and they're waiting for the district town planner of Faridabad for the NOC.
Who is Ayush Maheshwari?
Lordship, they're their representative. Mine was, Your Lordship, Mr. Sondip Dasgupta.
Sudeep
And Dasgupta.
Sudeep Dasgupta.
Yes, Your Lordship. That, Your Lordship, page 141, clause number 5, Your Lordship, this is. And Your Lordship, top of that, just below the place of meeting, attendees present for Burgess is Sondip Dasgupta. Attendees present for GPHP Holdings is Alok Maheshwari. Alok, Ayush, and Nitin Daga.
You could not find any person in Calcutta.
But they came down to Calcutta. But this, as a matter of fact, if the Lordship kindly sees this minute, it is as a matter of fact taking place at Berger House in Calcutta. My lord, if your lordship kindly takes 142 once, page 142. My lord, this is from Ayush Maheshwari. My lord, kindly sees place of meeting after dear sir, my lord. Berger Prince Corporate Office, Newtown, Calcutta.
Yes.
Now, my lord, the point is very simple. Today, my lord, my point is not only on the point that I am asking for an injunction because I have a case of, my lord, money claim. I'm going one step further. There is a case of judgment upon admission. Judgment upon admission, Order 12, Rule 6. My lord, kindly sees this page 142, my lord. The last clause, thereafter as requested, a hard copy of the scheme was handed over. So, my lord, this is the scheme which has been made by the defendant to be placed before the NCLT as a compromise petition. My lord, that starts at page 143.
What has happened to the NCLT?
My lord, it's the first stage, my lord. Notice will be issued.
Go.
And I cannot. My lord, as a matter of fact, I won't, my lord. Why I'll point out, my lord? The point, it's very simple, my lord. Why I'll point out, my lord? I am not bound by a scheme, my lord. It is my right as to whether I will take it or not. My lord, kindly comes to page 159. Oh, no. 155. Your lordship is seeing the plaint, I believe, my lord.
Yes.
My lord, is on the plaint or the petition, my lord? I'm not too sure, my lord.
Plaint.
But 155. Now, my lord, can you see operational trade creditors? Your lordship has found that, my lord? The outstanding debts of operational trade creditors of such and such has been reduced by 80% and settled at 20%. Where did they get that? I have said I'm not interested. Now, kindly see the entry at serial number 4.
You are there.
99 lakhs.
Correct.
They are trying to bring it down to 19 lakhs. 19 lakhs. 10% of what? Well, that is why I'm before your lordship. It's an admission. Once there is an admission, my lord, I'm entitled to an injunction. And my lord, your lordship, Mr. Shengupta has shown your lordship, my lord, at the very threshold they have started that we have closed down, we are trying to sell the asset and give you the money. Now they are saying otherwise. I'll sell the asset and money they are trying to give me, my lord, peanuts. Now 10%, 10.63%. That is why I'm before your lordship, my lord.
Yes.
And that's why I was sought for urgency, my lord, also. And my lord, your lordship is also well aware, my lord, as the creditor, my lord, as the debtor.
Where you say urgency, prayer?
Yes, my lord.
Pleading?
My lord, I'll just come to the plaint, my lord. I'm sorry, my lord. My plaint has urgency pleading. I'm sorry, my lord. My lord, the petition, it is there, my lord. Plaint, my lord, 12, I'll just point out, my lord. My lord, paragraph 14, 13 onwards, my lord, 13 onwards. At para 14, I have said on 24th March, we were informed again by them. And then, my lord, (18, 19). 19 is my lord, main averment that in the event the factory is sold, we'll have no other valuable rights. And therefore, there is extreme urgency for immediate urgent interim relief. And 20, my lord, therefore, I have sought for dispensation of compliance of 12A. And my lord, clause 12, leave, my lord, I have also sought for, my lord, for both within and outside, my lord, pleaded that.
So bring for the plaintiff.
And the plaint is being presented also today, my lord.
The plaintiff has filed the present suit, praying for recovery of an amount of rupees 1,14,99,179, along with interest at the rate of 18% per annum. The plaintiff has prayed for leave under clause 12 of the latest patent on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. The plaintiff has also prayed for dispensation of section 12 capital A of the Commercial Court Act 2015 on the ground that on the ground that from the month of February 2024 to June 2024, the plaintiff has February 2024 to June 2024, the plaintiff has supplied goods total valued of rupees 1,01,60,721. But the defendant has not paid the said amount. Now the plaintiff came to know now the plaintiff came to know that the defendants are going to close their factory and sell closure of the operation of blade plant located at Sarurpur, Sarurpur, page number 7, industrial area, Faridabad. Full stop. Counsel for the plaintiff further submits that the defendant again on 24th of March 2025 informed the representative of the plaintiff that the defendant is going to sell the factory land being plot number 23, gully number 3, Sarurpur industrial area. Full stop. The counsel for the plaintiff further submits that the defendant has already informed the plaintiff that the defendant is trying to sell the factory, and if the defendant is allowed to sell the factory and the defendant will not pay the due amount to the plaintiff, the plaintiff will suffer irreparable loss. And there is no other property of the defendants within the knowledge of the plaintiff. And as such, if at this stage the plaintiff will go for the pre-institution mediation process, there is every chance that in the meantime the defendant will sell the factory and the right of the plaintiff will be deputized. Consider the submission made by the counsel for the plaintiff. Peruse the materials on record and the pleadings. This court finds that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent 1865 is granted. Full stop. This court also finds that the plaintiff has categorically pleaded with regard to the urgency that the defendant is going to sell the factory, and if at this stage the plaintiff is allowed to go for the pre-institution mediation, there is every chance that during the pendency of the mediation process, the defendant will sell the plant, for which the plaintiff will not be in a position to execute the decree in future, if any, passed by this court. Considering the above, dispensation under clause 12 under section 12A of the latest patent is also granted. Full stop. Plaintiff is admitted subject to scrutiny by the department. Okay. Full stop. Number next. The plaintiff has also filed an application being GA Form 1 of 2025, praying for ad interim injunction, restraining the defendants. Their man an agent for transferring, alienating, encumbering, dealing, or disposing of their factory situated at plot number 23, gully number 3, within bracket west, Sarurpur industrial area, Faridabad, Uttar Pradesh. Full stop. This full stop. During the month in between February 2024 to June 2024, the plaintiff has supplied the goods to the defendant for a total sum of rupees 1,01,60,21. The plaintiff has disclosed the invoices sent to the defendant along with the materials, and the details of the invoices are also disclosed in the print. Full stop. The defendant has not raised with regard to the receipt of the materials and the use of the materials, but the defendant has not paid the amount to the plaintiff. Full stop. The full stop. In the meeting held on 12th of February 2025, the defendant has categorically stated that the defendants are in a precarious condition of their precarious financial condition, and as such they intend to close the factory and to sell the said factory, which is the assets of the dependent. Full stop. The full stop. The again a meeting was held on again in email was issued on 24th of March 2025, wherein the defendant has again informed that the defendant is going to sell the factory of the defendant. Full stop. The defendant has also framed the scheme wherein the defendant has admitted that the total outstanding amount of the plaintiff is rupees 99,08,520. But in the scheme, they have reduced the amount only to the extent of 10%. That is rupees, reduce the settlement amount at the rate of 10%. That is rupees 19,81,704. Consider the above, this could find that from the invoices it is prima facie proved that the plaintiff has supplied the materials. The emails also proved that the defendant, the financial condition of the defendant is precarious. Financial condition of the defendant, there is a precarious condition of the financial. He is also precarious. Full stop. The defendant is also by the meeting and the email, it is also found that the defendants are interested to sell the property. Full stop. Instead of paying the amount, the defendants have settled the scheme only to the extent of rupees 19 lakhs instead of rupees 99 lakhs. Considering the above, this court find that the plaintiff has made out a FFSA case and balance of convenience and inconvenience are in favor of the plaintiff. This could find that if at this stage the defendants are not at this stage an identity order is not passed, there is every chance that the defendants will sell their property, for which the plaintiff will suffer irreparable loss and injury in future. Accordingly, the defendants, their men, agent, servant, assigns, representatives are restrained from alienating, encumbering, dealing or disposing of creating any third party interest over the factory situated at plot number 23, gully number 3 within bracket West, Sarurpur, SARURPUR, Sarurpur Industrial Area, Faridabad, -121004, Uttar Pradesh, till 6th of May 2025. The plaintiff is directed to immediately send the copy of the plain, documents, application to the defendants by speed post and to file the affidavit of service on the returnable date.
The returnable date is also the 6th, Malad.
Let the matter appear on 6th of May 2025.
Very good.
Under the heading new motion. Next.
Please, Your Lordship. Item number 16, my lord, I am for the plaintiff.
Yes.
An application has been taken out by the respondent, it's GA8. Lord, if pleadings are complete, my lord, this is a petition by which, my lord, the respondent is contending that this petition, this suit is not a it should not be filed in commercial division. It should be a non-commercial suit. It has to be heard out. But I do not find them.
Who is for the defendant? Nobody.
My lord, Miss Shormi Dotto was appearing.
Siddhartha Banerjee.
And Mr. Siddhartha Banerjee for one of the defendants. My lord. There are two defendants. My lord.
Defendant number 1.
Defendant
Who
number
has filed this application?
It's by defendant number 1.
What is the ground? Non-commercial?
They say, my lord, this dispute does not fall under, my lord, 21C.
C.
The definition is not satisfied. That's their contention, my lord. We have stated that this dispute.
Pleadings completed.
Pleadings are complete.
Nobody is there. That I am adjourning for interest of justice. If next date they will not come, then it.
My lord.
So and so suffering for the plaintiff. None appears on behalf of the defendant. The defendant has filed the present application being GA Form 8 of 2024. Praying for recalling of the order dated 1st March 2024 passed in CS 110 of 2007 within bracket new CS com number 610 of 2024 and to transfer the said case from commercial division to non-commercial division. It is fine from the record, pleadings have been completed, but none appears on behalf of the defendant. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 14th May.
But may it be on any other day other than 14th, my lord. Any other day, my lord.
16th May.
My lord.
16th May. Under the heading adjourn motion. It is made clear that on the date fixed, if the defendant fails to appear before this court, the application filed by the defendant being GA of 2024 will be taken up for hearing in their absence. An appropriate order will be passed in the said application.
Deeply obliged.
That it's regarding, my lord, an application under Order 38 Rule 6, my lord, in which, my lord, on the last occasion, my lord, your lordship had granted, my lord, on the previous to last, my lord, your lordship has directed the learned special officer, my lord, to take, my lord, symbolic possession.
He has done.
He has done that. Now your lordship on the 7th of April directed us to take instructions with regard to the Hemanto Mukherjee Sharoni flat and also the accounts. Now, my lord, which was sold by the SBI bank, my lord, to some other persons, my lord. Now, my lord, with regard to the report, my lord, only a few things, my lord, perhaps for certain further orders. My lord, with regard to the Hemanto Mukherjee Sharoni, my lord, perhaps, my lord, I will need a direction upon the bank officers, my lord, to disclose, my lord, where to what extent, my lord, since they have sold it, it must have been a mortgage. So, to what extent, what was the sale proceeds which had come in, and what was the amount? If it was in excess, it was paid back to the defendants. That is one. With regard to the Hemanto Mukherjee Sharoni and with regard to the other flats, my lord, which he has taken symbolic possession, my lord, I would request your lordship, my lord, to pass an order of physical possession with regard to, my lord, the 2 flats at the Merlin Park, my lord, which is on the special officer's report, my lord, at page 5, serial numbers 1 and 2.
GA? GA3?
The special officer's report, my lord, in GA3. Special officer's report.
Page?
My lord, page 5.
Flat number?
My lord, flat number 5-1.
First floor, Merlin Warden.
Yes, and serial number 2, my lord. 104.
Yes.
My lord, because 104, he has said that there was already a padlock. But the thing is that, my lord, inventory, but we know that it's the office of the defendant, because your lordship kindly comes to the page, my lord, 10 and 11, my lord, 9 and 10. Sorry, my lord, 8, 9 and 8, 9 and 10 and 11. My lord, it shows, my lord, it's the office of the defendant. So these 2 properties, my lord, physical possession may be taken. my lord, an order for attachment can be passed. And thirdly, my lord, I would request, my lord, I would urge your lordship, my lord, to pass an order, my lord, directing the defendants to be called for before the court for one reason, my lord, with regard to the two deeds, with regard to the Hemanto Mukherjee Sharoni. One was the flat which has been sold. The other is the flat number 4, which could not be found, though a sale deed was executed. Now, my lord, what I have found out as the instructions are, my lord, the registering authorities are not the persons who can be held liable, because it's a deed which is there, they assess it.
That's
And
on the last occasion.
yes, so the
Who is the
defend,
authority
yes,
here?
so the defend, my lord, the authorities, the defendants need to be called for, and
If the defendants will not come out, what will
then
because see,
then I'll need a warrant of arrest then.
no, who will be, who is the authority of the land record?
We are
and
no
the-
one, my lord, to investigate as to whom the flat belongs. My lord, if it has been sold to someone
No,
else,
that is the see, that is the deed. Deed, there is a flat number.
yes, flat number 4.
That flat number
4.
there is a report. Another there are two
Yes.
reports, no?
There's one report. I believe.
दूसरा एक report.
One report, my
One
lord.
report. Where is with regard to the
Lordship comes to page 5, the last one, serial number 4.
lying the second floor, a symbolic possession could not be taken and no such flat at the premises.
But a deed exists where the schedule is flat number 4. So the defendant needs to be called for and examined as to how flat number 4 has gone. My lord, my presumption is in that building and complex, the flats are numbered according to the floor. One is 202, which is on the second floor. Now 4 is a very peculiar number which is coming in. It may be a typographical mistake, which the defendant can only say whether it is on the 4th floor and some flat number. So, my lord, let the defendant be called for first. Let us find out, and thereafter we can proceed.
No, if the defendant is not appearing in the civil suit, how the court can do further?
My lord, Order 38, Rule 6 is the attachment is in the nature of an execution procedure.
Correct.
So, warrant of arrest can be issued by your lordship.
No, warrant of arrest if the property is not there, the property is
No,
there.
if the defendant does not come before your lordship, like in
Property is there, they are not coming. The symbolic possession is being given. Now the
property is not there. What he says according to the way, according to the deed.
So that's why this property that is it is the duty of the plaintiff to identify.
Well, the plaintiff cannot. It can. But it's the defendant. If he has executed a false deed, it's the defendant who will be liable. So that is the reason why the defendant needs to be called for to find out whether the execution of the sale deed was proper.
There will be a society.
No, it's not the society, my lord. It's
Where
the
is the
private
deed?
flat.
Where is the deed?
My lord, the deed, my lord, is at page volume 2 of the application, perhaps. কোন volume এ আছে না?
Where is the deed?
Yes, madam.
Page
1 second.
Page 70.
Page 7. কোথায়? Yes, page 70, volume number 1. The second schedule, all that one self-contained residential flat with such and such flat number 4 lying on the second floor at southwestern side, having 2,700 square feet with a car parking space. So it is the defendant who has executed it. So the defendant needs to be called for and found out what is the details with regard to the execution of this deed.
CPC दो.
এটা জানি এক্সিকিউশনটা চাইছি। Lordship kindly comes to order 38 rule 7.
I want to. That's why as per attachment.
Yes.
But the attachment, see, identification, how the identification can be made.
So that can first, my lord, has to be made. my lord.
Okay, special officer stating that there is no flat.
It's no
Could
flat.
not
So
find.
there is a deed.
There is a
So
deed.
the defendant has to be, needs to be called for.
If the defendant is not coming forward,
My lord, then in the nature of an execution proceeding, warrant of arrest.
for your identity, see, warrant of arrest be issued with regard to the no properties there, and you want the warrant is to be issued and the defendant has to send to the prison.
But that is
Civil
also,
prison.
here, my
That
lord,
is one.
also, my lord,
Here,
obstruction of.
here you are having the property details. The property details which you are having, that property details, 3 property details. Okay, the fourth one is the deed is there, the property is missing.
Yes.
Correct.
Yes.
So with regard to the if that property is missing, then you have to take appropriate steps.
That would be, my lord, in fact, my lord, obstruction of execution by the defendant.
There is no report obstruction. There is no report. The flat is not there. Where is the obstruction? That's why I'm telling you the obstruction. Then you can the court can pass an order. We can call for the report of the police. How many police persons is there? You have to deposit the amount, and the police person will take the possession. But here the identification of the property, identification of the property, identification of the property is of you. So now because this flat is situated in the municipal premises.
Yes.
Correct. So either you have to ascertain from the municipality. I don't know what is in the Calcutta because it is a revenue land, it is a district collector, whatever it may
No,
be.
it would be the municipal assessor.
Assessor. So municipal, because this is a flat, so naturally the property tax is the municipal. Naturally, the
Yes.
municipal tax and all these things is to be paid.
Yes.
And this all the things are online. You can check it or not. You have to contact with the assessor.
Well, your lordship passes an order of attachment with regard to the 2 Merlin properties, and will then call for the SBI officer to furnish an affidavit as to what was
Which SBI officer?
my lord, who has sold the my lord flat number, my lord,
Bank account maintain Federal Bank.
flat number, my lord, 202.
Where from you are getting?
My lord, serial number 3, my lord.
Flat number 202, symbolic could not be.
As the property belongs to Rajoshi, my lord, my lord, your lordship kindly comes to, my lord, paragraph where it's an admitted position, my lord. Your lordship kindly comes to page 15, my lord, of the report. Paragraph 15 of the report, my lord. Sorry, my lord. Kindly comes to paragraph 7. My lord, your lordship sees the lower portion of paragraph 7 just above serial A. It was intimated to me by the plaintiff that the defendant by way of 2 registered deeds, that the details are as follows: flat number 202 lying at then your lordship sees 8, the caretaker as well as the security guard intimated that there was a flat initially owned by the defendant, which was taken possession of by State Bank of India and thereafter was sold to one Mr. Rajoshi Lahiri, but I was not allowed to enter. Then your lordship comes to paragraph 15. Upon visit, I went to the flat at P499 Hemanto Mukherjee such and such, where I met Rajoshi Lahiri, who showed me an original deed by which he has purchased the flat from the State Bank of India and as such is the owner.
This might be in the death recovery tribunal. What you will get? There will be a loan. they have taken the surface, they sold it, and he is the owner.
So that is the reason why let a State Bank of India officer furnish an affidavit to that extent
What?
as to whether an amount, any sale proceed, excess sale proceeds.
Sir, for you, the court cannot collect the evidence. You have to collect all these things. How the court can say yes, this is a report? Then you have to collect the evidence, sir. There might be a surface in they have sold that.
There may be.
So
There must be maybe. Your lordship would grant an attachment, my lord, in respect of the two flats, my lord. That is flat numbers, serial number 1 and 2.
So who is the authority or attachment? Flat.
Well, these flats, my lord, belongs to the defendant numbers 1 and 2. Paragraph, my lord, 3 says that, my lord, wherein I found Mr. Anjan Kumar Das who were claiming themselves as directors of the defendant. Paragraph 3. And paragraph 5. That he has been able to do, my lord, in the presence of the plaintiff.
Yes. That's all.
These are the two, my lord. I don't think there's nothing in the bank.
What about the HDFC bank?
Well, the HDFC bank, they have said they have got no balance.
One rupee suffering for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submitted as per the report of the special officer. Two properties, that is flat number V-1, comma, first floor, comma, Merlin Warden Lake View, comma, 104 Bidan Nagar Road, comma, Kolkata, dash 70067, comma, West Bengal, and Merlin Warden Lake View, comma, 104, comma, Bidan Nagar, first floor, block dash 1, unit F and G, Kolkata, 70067, West Bengal, belonging to the defendant shall be attached as the said property has already been taken as the special officer has already taken symbolic possession of the said property. Consider the submission made by the counsel for the plaintiff. Full stop. Counsel for the plaintiff. Counsel for the plaintiff. Full stop. This court find that in spite of several notices, comma, the defendant failed to appear before this court. Accordingly, this court has appointed the special officer for taking symbolic possession of the property in question, property of the defendant. Accordingly, the special officer has submitted the report wherein the aforesaid two properties have been taken symbolic possession by the special officer, but the inventory of the said premises could not be made. No. Inventory of the second property, that is Merlin Warden Lake View, comma, 104, comma, Bidan Nagar Road, comma, first floor block dash 1, unit F and G, Kolkata, 70067, could not be made as the same was under padlock. But with regard to the flat number V-1, 1, first floor, Merlin Warden Lake View, 104 Vedan Nagar. Inventory was also made, which is appearing at paragraph 5 of the report of the special officer. Considering the above, the special officer is directed to attach the properties of the defendant, that is flat V-1, first floor, Merlin Warden Lake View, 104 Vidhan Nagar, Kolkata, Vidhan Nagar Road, Kolkata 700067, West Bengal, and Merlin Warden Lake View, 104 Vidhan Nagar Road, first floor, block 1, unit F and D, Kolkata, 700067, West Bengal, in presence of the plaintiff. After notice to the defendant, if on receipt of the notice that the defendant failed to present before the special officer at the time of attachment, the special officer has a liberty to attach the same in the absence of the defendant but in presence of the plaintiff, and to make appropriate proceedings at the time of attachment of the property. It is made clear that at the time of attachment of the property mentioned, property of the defendant as mentioned above, the special officer found any difficulties or restraint from the defendants, the special officer shall be at liberty to make appropriate complaint before the police authority for appropriate police authority to provide police assistance, and if any request is made by the special officer to the concerned concerned officer in charge or any competent authority of the police authority of the concerned police station, the concerned police officer shall provide sufficient police force to the special officer for attachment of the property by the special officer in presence of the plaintiff. Police. The special officer is directed to attach the property within a period of 4 weeks. 4 weeks from date, and to submit the report before this court on 3 weeks and to submit the report 3 weeks, and to submit the report before this court on 8th of May 2023. The remuneration is up to your lordship. The remuneration, the plaintiff shall pay the initial remuneration of the special officer to the tune of rupees 30,000.
The two flats, flat number 6,
both are given,
of Merlin. Great.
Next.
Lordship, I appear for the plaintiff in this matter. Like the examination in chief was going on, Lordship.
Where is our witness?
Yes, Lordship.
It is going on. Cross-examining that. Order sheet. Examination chief is different. You have not gone through the chief.
Lordship? Yes, Lordship, it is all is okay. I thought of correcting few, but then I think it's okay if it goes down that way.
What is your
Lordship, just one before I start the examination. Only the documents that were marked as exhibit were the originals. So if I can just put one question as a whole of the exhibits, the ones those were in original, and he can just
exhibited?
Yes, Lordship.
So what question you want to put now?
That whether they were all originals or not. Specifically, if I may mention, exhibit A, B, C, D, C, E. Thereafter, F, H, I, and K, they were all originals. Mr. Lakkar, on the last day, you have deposed few documents which were marked as exhibit, being exhibits, being exhibit A, B, C, E, F, H, I, and K respectively, which you have handed over before this honorable court. Were these documents all originals?
Yes, original.
Yes, those are the original documents. देखो original है. Exhibits का है.
Kindly, मैं judge's brief का बात करूँ. Come to pages 104 to 107 of the judge's brief of documents. Kindly tell my lord, what are these documents?
पेज नंबर 104 से 107 देखिए, तो माय लॉर्ड को बोलिए ये डॉक्यूमेंट क्या है.
ये सुप्रीम फेट कैरियर का लेजर है, ओवरसीयर इंटरफेस.
The ledger of Supreme Freight Way Carriers. बोलिए.
दीपक अग्रवाल ओवरसीयर इंटरफेस डायरेक्टर और अकाउंटेंट ने बनाया है.
This ledger was prepared by Deepak Agarwal, accountant of Oversure Enterprises Private Limited. Accountant of Oversure Enterprises Private Limited.
Wrong, Bullish. You have taken it wrong. He has taken it wrong, Lordship. He's mentioned something else. Again, ask.
Deepak Agarwal.
सुपर फ्रेड मूवियर फेट वे कैरियर दीपक अग्रवाल के अगेंस्ट में ओवरसीयर इंटरफेस का लेजर है. ये
दीपक अग्रवाल कौन है ये तो बोलिए.
सुप्रीम फेट वे कैरियर डायरेक्टर.
This is the ledger prepared by Deepak
No,
Agarwal.
Lordship. This is the ledger prepared by Overshore Enterprises for Supreme Freightway Carriers.
Deepak, he's telling
Deepak Agarwal is the proprietor of Supreme Freightway. Lordship, kindly sees the cost title. Cost title, it says Deepak Agarwal, sole proprietor of Supreme Freightway Carriers.
ये जो पेज है क्या है ये?
लेजर है सर.
किसका लेजर है? This is the ledger of किसका लेजर है?
सुप्रीम फेट कैरियर फेटवे कैरियर सुप्रीम फेटवे कैरियर.
The ledger of Supreme Freightway Carriers. किसने उसको बनाया प्रिपेयर किया है?
डायरेक्टर ओवरसीयर इंटरफेस.
बनाया किसने है ये लेजर प्रिपेयर?
अकाउंटेंट.
कौन?
अकाउंटेंट ओवरसीयर इंटरफेस का.
Was prepared by the accountant of Oversure Enterprises Private. By the accountant of Oversure Enterprises Private Limited. Yes, next question.
What is the time period which was for which this ledger was prepared?
इस लेजर में किस टाइम पीरियड तक दर्शाया गया है?
1 अप्रैल 2016 से
from 1st April 2016 to
30 नवंबर 2020 तक का है.
30th November 2020.
30 2020.
So pages का हमें 104 to 108, not 107. What is the outstanding amount as per your ledger?
लेजर के मुताबिक जो अमाउंट आउटस्टैंडिंग है बाकी है वो कितना है?
30,75,000.
Outstanding amount is 30,75,000.
Are the contents of this ledger true and correct?
लेजर में जो कंटेंट्स है जो कुछ भी लिखा गया है क्या सच है सही है?
सही है.
It's true and correct.
Lordship, this may be marked as an exhibit.
The original is a Xerox copy.
The Xerox copies, Lordship.
Where is the original?
Originals, they don't have, they're all prepared It's all prepared by them. Even if they prepare, it'll be on plain sheet of papers, Lordship. I'll just hand over. I have a copy of that. It's not on their letterheads. এটা দিয়ে দিন।
There is a seal. Where is the original seal paper?
Not mentioned here. This is what was annexed to the plaint also, Lordship. This is how it was annexed to the plaint.
Yes. Go through. Your original is in the plaint.
Yes, Lordship.
You are not inspecting the record before coming with the witness.
I apologize, Lordship. This is a very old matter.
वो पेज को exhibit करो.
In that case, Lordship, should I change the question?
Oh, madam, the question which has been put, na, that page number 10, not page number 94 to 91 to 97, na?
Of the plaint.
Last one, 95. 91 to 95 of the plaint.
Deeply applies, Lordship. If they be marked as exhibit, Lordship.
Last year. Exhibit L. Collectively. Huh?
Yes.
Kindly come to page 110 of the judge's brief of documents and tell my lord what are these, what is this document. Lordship, this is already filed before my the court. Forms a part of the pleadings in one of the applications.
तो 10 पेज में देखिए ये डॉक्यूमेंट क्या है माय लॉर्ड को देखिए
ये एफिडेविट इन ऑपोजिशन दीपक अग्रवाल के वकील ने मेरे एडवोकेट को दिया था.
This is an affidavit of opposition which was given by the advocate of Deepak Agarwal to my advocate.
Have you gone through the document?
क्या आपने ये डॉक्यूमेंट को पढ़ा है?
हाँ.
Yes, I have gone through.
Who has signed this document?
डॉक्यूमेंट में किसका हस्ताक्षर है? किसने साइन किया है?
दीपक अग्रवाल ने.
The document was signed by Mr. Deepak Agarwal.
Can you encircle the signature of Deepak Agarwal in blue?
Deepak Agarwal का signature जो है?
It's the original or copy?
Lordship, that is a copy. Original is filed before the court. Plate na GA1 একটা opposition আছে. দুটো opposition আছে.
G1 तो नहीं है यहाँ.
Lordship, should I hand over one copy to you? No. Take it out. Internal page 16, Lordship. Are the contents of this document?
Encircle कीजिए. नील पेंसिल से दीपक अग्रवाल का signature. The witness encircled the signature. जी गोल कीजिए. The witness encircled the signature of Mr. Deepak Agarwal appearing at page number 126 of judge's brief of document.
Are the contents of this document true and correct?
No.
No.
Lordship, this may be marked as an exhibit.
Exhibit. Yes, next.
I'm showing you an original letter. A document. Kindly tell my lord what is this document. Letter होगा ना document होगा.
इस डॉक्यूमेंट को देखिए और माय लॉर्ड को बोलिए ये क्या है.
ये मेरे एडवोकेट ने दीपक अग्रवाल के एडवोकेट को कॉपी ऑफ प्लांट भेजा. कॉपी ऑफ प्लांट भेजा.
ये क्या है?
ये लेटर है.
दिस इज अ लेटर.
This is not in the judge's brief of document.
Lordship, the
Page
Xerox
number.
copy, page 128. Page
Page.
128 of the judge's brief of documents.
Shown, which is appearing at some. Copy of which is appearing at page number 128.
128 of the judge's brief of documents.
Yes. ठीक है, ओरिजिनल दिखाइए.
आंसर. आपके एडवोकेट ने दीपक.
मेरे एडवोकेट ने दीपक अग्रवाल के एडवोकेट को कॉपी ऑफ प्लांट भेजा.
My advocate sent the copy of the plaint to the advocate of Mr. Deepak Agarwal. This is mentioned in this letter. This fact has been written on this letter.
Are the contents of this letter true and correct?
क्या इस लेटर में जो कुछ भी लिखा हुआ है वो सच और सही है?
सही है.
Yes, true and correct.
So this may be marked as an exhibit.
Where is the endorsement?
Lordship, kindly can you encircle the endorsement of the advocate for Mr. Deepak Agarwal?
दीपक अग्रवाल का जो एडवोकेट है उनका क्या कोई सही है? उसको आप एनसर्कल कीजिए.
यहाँ पे सही है.
क्या आप देख पा रहे हैं सही?
हाँ, ये है.
उसको एनसर्कल कीजिए ब्लू पेंसिल से. The witness encircled the signature of the advocate of Mr. Deepak Agarwal with blue pencil.
This may be marked as
Exhibit. Yes, next.
Lordship, then there is the order of the court, honorable court, coordinate bench. And
Yeah,
they are not-
argument you can place it.
Lordship.
Order need not to exhibit.
Lordship. Thereafter, kindly come to page 137 of the judge's brief of documents and tell my lord what is this document.
पेज नंबर 137 को देखिए और माय लॉर्ड को बोलिए ये क्या है.
এটা দেখিয়ে দিন তো. এটা কিন্তু প্রিন্ট আউট. জাস্ট প্রিন্ট আউট আছে, আপনি দেখিয়ে দিন.
एचडीएफसी बैंक को कोर्ट का मेरे एडवोकेट ने एचडीएफसी बैंक को और दीपक अग्रवाल के अकाउंट को फ्रीज करने के लिए कोर्ट का ऑर्डर भेजा.
This is a copy of the email by which my advocate sent the court notice to HDFC Bank Limited on by which notice was
By which the order passed by this court was communicated.
the order of
Order passed by this court dated 5th of July 2023 was communicated.
proceeding of the account of the Deepak Agarwal.
Next.
Who has sent this mail?
ये email किसने send किया?
ये मेरे एडवोकेट ने किया.
This email was sent by my advocate.
How have you received the printout of this mail?
इस मेल का प्रिंट आउट आपको कैसे मिला?
ये मेरे एडवोकेट ने निकाल के दिया.
My advocate has taken out the printout and given it to me.
Are the contents of this document true and correct?
करेक्ट.
Yes.
Kindly come to page 139.
Just a minute, just a minute. This mail contains any document?
क्या इस मेल में कोई document है?
He has already.
PDF.
Yes, Lordship, he has already mentioned that in the reply.
Has to say.
Yes, there is an attachment.
I want
What you are doing, madam? If it is a contested case, then you will be out.
I have followed what is.
Yes, next.
So this may be marked as an exhibit.
Exhibit. Yes, next.
137, 138. Kindly come
137 and
138.
Which? Madam.
Showing you the documents at pages 139 and 140 of the judge's brief of documents. Kindly tell my lord, what is this document?
ये डॉक्यूमेंट देखिए और माय लॉर्ड को बोलिए ये क्या है.
ये दीपक अग्रवाल के बैंक ने भेजा कि ऑलरेडी अकाउंट उसका फ्रीज है.
The bank of this mail was sent by the bank of by Mr. Deepak Agarwal, informing that his account on their branch or bank is already freezed, has already been freezed.
To whom was this mail sent?
ये मेल किसको भेजा गया था?
ये बैंक को भेजा गया था, HDFC बैंक.
This mail was sent to HDFC Bank.
Repeat the question.
किसको भेजा गया था ये मेल?
Who have sent to whom?
किसने किसको भेजा था ये मेल? आप बोलिए. किसने ये मेल भेजा था और किसको भेजा था?
ये HDFC बैंक को भेजा गया था.
This mail was sent to HDFC Bank by whom? किसने भेजा था?
मेरे एडवोकेट ने.
My advocate has sent this mail.
Yes.
The witness turns hostile. What does this mail state?
आप पढ़ना जानते हैं? थ्रू कोर्ट. आप जो है इंग्लिश पढ़ना लिखना जानते हैं?
नहीं, इंग्लिश पढ़ना लिखना नहीं जानता.
He can, but slowly.
उन्होंने कहा नहीं.
नहीं, I can't read and write English. Gone.
So because he reads and he says, that's the reason.
It's not telling anything, madam. It is against you. ये इस मेल में क्या लिखा है मालूम है?
मेल में क्या लिखा है आपको पता है?
हाँ या नाम है बोलिए पहले. मालूम है? क्या लिखा है? किसने भेजा है मेल?
ये जब मैंने ऑर्डर भेजा
ये
था,
मेल जो है आप पढ़िए. मेल किसने किसको भेजा है पहले पढ़िए. आप विटनेस बॉक्स में आए हैं.
ये स्वाति अग्रवाल ने भेजा है और HDFC का रिप्लाई आया.
It was sent by Swati Agarwal. The reply came from HDFC Bank. And the reply came from HDFC Bank.
Yes. Next.
What does the bank state in its reply?
बैंक ने उनके रिप्लाई में जवाब में क्या लिखा है?
जवाब में लिखा कि उनका अकाउंट ऑलरेडी फ्रीज हुआ.
In their reply, the bank has stated that the account has already been freezed. The account of Mr. Deepak Agarwal has already been freezed. Deepak Agarwal has already been freezed.
From where have you received this document?
आपको ये डॉक्यूमेंट कहाँ से मिला?
ये मेरे एडवोकेट ने मेल से निकाला.
My advocate has taken out the printout of this document from email ID.
Are the contents of this document true and correct?
क्या इस डॉक्यूमेंट में जो कुछ भी लिखा है वो सच और
सही
सही?
है, सही है.
Yes, true and correct.
So this may be marked as an exhibit.
He has stated anything. How it will be marked? You have to examine yourself. It's not stated what is the document.
This should be He has
He
stated.
stated opposite.
Lordship, thereafter he stated that the mail was sent through Swati Agarwal and the reply has come from the bank. That he has specifically stated.
You have to prove your document, madam. He's stating that he's not having the knowledge. So much concession cannot be given. You are bringing the witness on dock without preparation.
Prepared.
Document is with you. Witness is with you. 4 days or 6 days you are having the holidays. And you have come and the witness is not telling anything. Yes, it will not exhibit it. Yes, next.
Just one more question. According to you, what is the amount that is outstanding from Mr. Deepak Agarwal, which oversure should be receiving?
दीपक अग्रवाल की तरफ से कितने पैसे बाकी था जो ओवरश्योर को देना था?
25 lakh principally plus interest. So within a 30 to 40 lakh.
The principal was
12% interest.
The principal was 25 lakhs and the principal and the interest was 12% per annum, which amounts to 30 to 34 lakhs, which amounts to a total of 30 to 34 lakhs as the outstanding amount.
Yes, next. That's all. So suffering for the plaintiff. Plaintiff witness is present. Examination chief resumed. During his examination, how many documents were exhibit? During his examination, documents were marked as exhibit L2O. Full stop. Examination chief of the plaintiff witness is closed. Full stop. Witness is discharged. Any witness further?
No, Lordship.
Counsel for the plaintiff submitted, she will not adduce any further evidence. Accordingly, evidence on the side of the plaintiff is closed. As none appears on behalf of the defendant, the case is going undefendant. Let the matter fix for argument on 15th May for argument.
Obliged, Lordship.
Next.
But I am for the plaintiff. My lord, this is a suit for my lord, money lent in advance where your lordship was pleased to pass a decree on a my lord, summary judgment application. My lord, that decree was affirmed till Supreme Court. Thereafter, my lord, the defendants, my lord, defense was struck off because my lord, they failed to my lord, put in the security, which was my lord, directed by your
It's
lordship.
not a decree.
Now, my lord,
Conditional leave to defend.
yes. And now, my lord, thereafter, my lord, what happened was, my lord, the defend number 3 had expired. Now, my lord, after, my lord, we got to know that the defend number 3 had expired. It is defend number 1 is a partnership firm. Defend number 2 is one of the partners. Defend number 3 was also one of the partners. Now, my lord, the defend number 3 is one of the sons, legal heirs, is defend number 2. Now, if your lordship kindly takes my lord GS6 once.
This is the application.
That's my application, my lord.
Yes, yeah.
Oh, I'm sorry. But if your lordship kindly turns to page 4, paragraph 5.
Yes.
Your lordship will find, my lord, that the
plaintiff is however come to learn that the aforesaid other legal heirs of the deceased defendant number 3 are now the other partners of the defendant number 1.
Your lordship is reading defendant number 2, paragraph number 5. Defendant number 2 is one of the son of deceased defendant number 3.
Yes.
Who is already on record. To the best of the knowledge of the plaintiff petitioner, the other legal heirs of the defendant number 3 are as follows. Prabha Saraf, which is the wife of the defendant number 3, Nupur Kejriwal, Shweta Agarwal, Shikha Patodia. So we had given the names and the addresses, and we had also indicated that they should disclose on affidavit the details of the other partners. Now, if your lordship kindly takes order 31 of the Code of Civil Procedure, your lordship knows this provision.
Order 30.
Order 30 of the Code of Civil Procedure, Rules 1 and 2.
Yes.
Rules 1 and 2, Order 30. Any two or more persons claiming or being liable as partners and carrying on business in India may sue or be sued in the name of the firm, if any, of which such persons were partners at the time of accruing the cause of action, and any party to a suit may in such case apply to the court for statement of the names and addresses of the persons who were at the time of accruing of the cause of action partners in such firm, furnished, verified in such manner as the court may direct. Now kindly see 2 also, disclosure. Where a suit is instituted by partners in the name of their firm, the plaintiffs or the pleader shall on demand in writing by or on behalf of any of the defendant forthwith declare in writing the names and places of residence of all persons constituting the firm on whose behalf the suit is instituted. It goes on saying the plaintiff or the pleader fails to comply with the demand made on the sub-rule, all proceedings of the suit upon that application we state and such, and where the names of the partners are declared, then whatever consequences follows. Now, there's a duty incumbent on the defendant to disclose the names of the partners. Now, they file an affidavit to this. Kindly takes the affidavit filed by the defendant numbers 1 and 2. A very short affidavit.
Defendant number 1 and 2, Nupur Kejriwal.
Yes, Niket Saraf.
Niket Saraf.
On behalf of Niket Saraf, which is the defendant number 2.
Niket Saraf.
Yes. The Lordship will find, kindly sees, they acknowledge that they have a incumbent duty to disclose their names of the partners. In paragraph 2, your Lordship will find the last line at page 2 of the affidavit. Prayer C they have quoted. Then they in paragraph 3 kindly turns the page. Paragraph 3 they say that I say that defendant number 1 was a partnership firm and consisted of only 2 partners, being the defendant number 2, Niket Saraf, and defendant number 3, Raja Ram Saraf. After the death of the defendant number 3 on 23rd January 2024, the partnership firm is yet in the process of being reconstituted. So, kindly sees the date of affirmation of this affidavit. This is on 1st March 2024. Now, kindly takes paragraph 4 of the opposition. I further say that in terms of prayer B, with respect to placing on record the address of Shweta Agarwal, it may be noted that Shweta Agarwal, wife of Sanjay Agarwal, is a British citizen and residing somewhere in the United Kingdom. And her current address is presently not known to the defendant number 2.
This is the old. Till
Yes.
date, it has not been decided.
Not been decided as of yet. We could not file an affidavit in reply to this because we could not continue though the heir of the defendant number 3 is on record, but without the firming, the partnership firm is not a legal entity as we know it. It's settled principle. It has to be represented through its partners. They say that it's still being reconstituted. That even in March 2024, they have not given the details of the partners who are the present partners of the firm. They are not giving the details of the legal heirs. So, I will be humbly beseeching your Lordship, whatever legal or whatever address of the legal heirs are known to the plaintiff that we have stated in paragraph 5, kindly gives me an opportunity to make a paper publication under order 5 for substituted service so that the legal heirs are represented. Now, interestingly, one of the legal heirs had come forward, which is Shweta Agarwal. If your Lordship kindly turns to the application. Nupur Kejriwal, I'm sorry. Nupur Kejriwal. Now, kindly turns to the application page 4, paragraph 5. The second legal heir, which is right there, Nupur Kejriwal, had filed an affidavit, and they are now contesting that they are not part of the partnership firm. She never was a part of the partnership firm, and she is not interested in the assets and liabilities of the partnership firm. That is the stand of Nupur Kejriwal. Be that as it may, I'll argue on the principle whether the legal heirs can be brought on record or not, because partnership firm, as we know it, is not a legal entity. It has to be represented through its partners. Either the partnership firm has been reconstituted, or they say the name of the partnership, they say the name of the partners and disclose their addresses, or they disclose the address of Shweta Agarwal, who according to them is residing somewhere in the UK. We have also written a letter to the British High Commission, but it was to no
we did not get a reply from there. Perhaps they do not have a reply. But I'll take my chances. Kindly gives me liberty to make paper publication in whatever address there is. In the one in in regional dialect and the other in an English newspaper, so that I can come back before your lordship. Whatever is the fate, I can file an affidavit and reply to that.
Since I am for the Nupur, since my affidavit has been Nupur case, since my affidavit has been referred.
Yeah, Nupur is different. First the defendant, then comes Nupur. Nupur is not even a party. He's a proposed defendant. Now, why have you filed an affidavit? Not required.
I will hear you. I will hear.
No, that's different. I am saying
That
that
first,
I am on the
whether the partnership is reconstituted or not.
My lord, kindly take the cause title once. My lord, my endeavor will be to substantiate before your lordship that this is a thoroughly misconceived application. My lord, kindly take the cause title. Suit against a registered partnership firm.
Where is it registered?
Which is Vinayak Mica Export Private Limited.
It's not registered.
So you could not have initiated an action unless it was a registered firm. Then, my lord, 2 and 3 has been impleaded, your lordship will see, as partners. So it's your action against the partnership firm along with the 2 partners. So there are 2 partners. So it is your case in your application that one partner has died during the pendency of the proceeding. So what is the legal effect? When one person dies amongst the 2 partners, when one partner dies, if your lordship will kindly now take one section, the Partnership Act once. C is aware.
I knew that 40C would be argued. That's why I placed before your lordship the opposition. The opposition clearly says.
But
that
the opposition cannot change the law.
It will be
the law will remain the law. So if your lordship will see,
so
may I hand over to your lordship?
Stand that the partnership firm has been now dissolved. Then all the more reason, then the legal has
I think it was my turn. We usually wait for your turn. I'm sure you'll have a right to rejoin once I complete.
Yes, section.
I can appreciate his anxiety. Kindly take section 42.
Yes.
Well, by operation of law, upon the death of one amongst the 2 partners, when there are 2 partners, one dies, by operation of law, the firm dissolves. Well, kindly take 42 once. Dissolution on the happening of certain contingencies. Now, my lord, kindly say C.
To contract between the parties.
By
the death of a partner. So upon the death,
yes,
there is a dissolution.
Yes.
Now, my lord,
That's
kindly
why
take-
after the dissolution, whether any fresh partnership was constituted or
No, my lord, I'll tell you, lordship, my lord, it cannot.
Why?
Fresh partnership cannot be constituted. If it dissolves, my lord, the dissolution has to be given effect.
Correct.
So, my lord, today, whether it is who will reconstitute, there is no right of reconstitution. By whom? 2 partners. Had there been more than 2, there was a situation of reconstitution. Now, he doesn't know what are the clauses of the partnership deed. So, you have come and made an application under Order 22 of the Civil Procedure Code, simpliciter, asking for the deceased person's heirs to be substituted. Well, this is not permissible in law when it relates to a action against a partnership firm. Your lordship will find this in Order 30, which my learned friend had referred. Kindly, my lord, once take Order 30 and take Rule 4 of Order 30.
So you are having the partnership deed?
No, my lord, they have not disclosed the partnership deed. They have, my lord, in their affidavit stated that they are yet to reconstitute the partnership firm. Now, my lord, 42, my lord, section 42 has been relied upon by my learned senior.
My lord, may I just
42 is,
conclude?
my
I
lord,
got
is
one small
subject to
judgment, then-
contract
then I-
between the parties. It's
Okay,
subject
okay.
to contract.
So have you disclosed the contract? Is it your case in the substitution application that the contract says that the legal heirs will automatically become the partners upon the death of the partners? You don't know. So based on assumptions, you cannot make a substitution application under Order 22. Now, my lord, kindly take Rule 4 once, Order 30, Rule 4. So he relied upon Order 30, Rule 1,
Yes.
which is wholly inapplicable
Yes.
at present in the facts of this case. What would be applicable is Rule 4.
Yes.
Right to suit on death of a partner, notwithstanding anything contained in Section 45 of the Contract Act. where two or more persons may sue or be sued in the name of a firm under the foregoing provisions, and any one person dies, whether before the institution or during the pendency of it shall not be necessary to join the legal representative of the deceased as a party to the suit. Then, my lord, nothing in subrule 1 shall limit or otherwise affect any right which the legal representative of the deceased may have. So, it is the legal representative who may come and say that that estate has devolved upon me. So, this person, his capital contribution or his asset in the partnership deed has devolved upon me. So automatically the liabilities I am also entitled to. So I am willing to take the liability. So nobody has done that yet. So my lord, rule 4 and section 42C is a complete bar in, my lord, asking legal representative of a deceased person to be impleaded in a partnership action. So what he has done is, in his application, if your lordship will see, he has named the surviving legal representative of the deceased partner, and he wants them to be impleaded. In law, it cannot be impleaded. So, I need not suggest to them what is their course of action. They have to. So my limited submission, so far as this GA is concerned, is that, my lord, under section 42C, by which, my lord, by operation of law, a firm dissolves, my lord, the legal heirs does not become liable for any liability of the deceased.
That's correct.
That's
correct. That is the law.
Correct.
Now you are appearing for whom? One. Correct.
So one, and the two, there's an individual there.
Right.
So one is today not in existence, effectively, technically
One is
dissolved.
not there is no partnership.
So
what about the firm?
So the firm automatically, you lordship see 42.
Correct.
By operation of law, it has dissolved.
Correct. It is dissolved.
Yes.
So it is dissolved
Right.
with regard to the legal here. Okay, the firm has dissolved.
Yes, my lord.
So this suit has been filed against the partnership firm. If the firm is dissolved, since one is alive.
Yes.
One is alive.
Yes.
So okay.
Yes. So you cannot, for a partnership action, whether he can pursue the claim against two or not, that will be eventually decided later on. But here I am restricting and confining my submissions to the substitution application. You cannot bring legal heirs, which we usually commonly refer to in the LRs. The LRs on record of a deceased tenant, not permissible in law. Well, kindly take this judgment once. A very short judgment of the Supreme Court. Give the two judgments.
I have not filed a reply to this application as of now to the affidavit. They have filed way back in.
I have not filed an affidavit. This is another factual correction. He kept on saying opposition of. I have not. But kindly see your lordship's order. Kindly see your lordship's order of 21st February. I have complied with the directions of the court. This is not an affidavit. Your lordship's direction, in terms of the order of 21st of February, I'll just read read your lordship's order. You have not been able to take it out, so what do I do? Well, 21st of February for your lordships, I'll just read out your lordship's order. It says, my lord, such and such appears, counsel for the plaintiff, present application is GA such and such, paying for recording of death of defendant number 3 and substitution of the legal heir. The court finds that before disposing of the application filed by the plaintiff, the defendant is required to file their affidavit disclosing the details as required by the defendant in terms of précis. Then, and also to disclose
whether the new
partners have been. So if I don't do this, I'll be in contempt. So I file a limited affidavit in terms of your lordship's order. What did I say here? I have said whatever my learned friend had read out, the 2 paragraphs. Yes. Now, my lord, if your lordship will see, order 30, rule 4, 50 to 42C is very clear. Now, my lord, kindly take the Supreme Court judgment, 2019, 10 Supreme Court cases, page 329. Boita kothay? 329. Well, this was in an execution proceedings. Well, kindly take once para 12. On the other hand, it is the contention of Sri such and such, learned senior counsel appearing on behalf of the respondents, that as there were only two partners, and on the death of one of the partners, the partnership stands dissolved. In view of the provisions of 42C of the Partnership Act, it is submitted that when the right of litigated upon is readable, only in such event decree can be executed. Now, my lord, kindly turn to paragraph 15 on the next page, page 334. On a perusal of the relief sought for in the execution petition by the legal heirs of the original plaintiff, itself makes it clear that relief sought for in the execution are going beyond the scope of the decree. I'll not trouble your lordship with that. My lord, one of the last sentence at placitum B, your lordship will see before ABCD, as per the said provision, subject to contract between the parties, the firm is dissolved when, my lord, ABCD is quoted, then, my lord, take para 16 once. In the case on hand, as much as there were only two partners, the partnerships itself stands dissolved in view of the death of a partner. It is true that as per the deed of partnership, the partners have agreed in the event of death of either party, their respective legal representative shall automatically become partners in the partnership firm, and they shall continue to act as a partners of the firm till the venture envisaged under the said partnership is completed, and such legal representative who become partners shall have the same right and shall be subject to same liability responsibility as the deceased partner. At this stage, it is to be noticed that once the partnership comes to an end by virtue of death of one of the partners, there will not be any partnership existing in which legal representative of late such and such could be taken in the judgment and decree obtained by such and such. Then it continues. Well, this is one aspect. Then, my lord, I will just trouble your lordship with another unreported judgment which has come recently. Give them a copy because it's an unreported judgment. But kindly once take one paragraph of this unreported judgment of Justice Bikram Nath. I'll airdrop my learned friend this judgment. This is, my lord, Annapurna B. Upin Amitichit versus such and such. My lord, kindly take the trouble of coming to paragraph 8. In fact, my lord, kindly take once paragraph 5, which would be internal page 10 of the judgment. 10 or 14, your lordship will find. Kindly take once 5.
Yes.
On the other hand, learned counsel for the respondent. Now, should I come back after 2? Because it's past lunchtime. Right. On the other hand, learned counsel for the respondent number 1, the contesting respondent made the following submissions. They refer to this judgment. Then, my lord, kindly take paragraph 6 once. This is the death issue was there. Then, my lord, kindly come to paragraph 8. Thirdly, para 8 starts with thirdly. There was no evidence on record to show that a fresh partnership deed was executed reconstituting the firm in which the present appellants had become partners, so as to take upon themselves the assets and liabilities of the firm. The law is well settled that legal heirs of a deceased partner do not become liable for any liability of the firm upon the death of the partner. Well, I rest my case here. No case made out by them in their GA application. Once they do, then we will see. Well, at this stage, legal heirs cannot be implemented in a partnership action against a partner.
To start off, two things. First of all, section 42 says that it is subject to agreement between the parties.
That's why, see.
And
So you
interestingly,
have not disclosed the partnership here. If the partnership is disclosed,
I'll
there
tell
is
you,
a
Lord,
clause.
I am an NBFC. I have given a loan to a partnership firm
who is represented by its partners.
Correct.
There were two partners at the time of accruing of the cause of action.
Yes.
And I have implemented those two partners along with the partnership firm.
Correct.
Which is sufficient compliance of Order 30. Now, after that, I do not know whether the partnership firm was registered, the partnership firm was an unregistered partnership firm. I do not know that fact. And I have, for sufficient reasons, I have included the names of the partners. Thereafter, what has been now argued before my lord is that section 42C will come into effect by operation of law. I will only join issue over here. 42C is subject to any agreement to the contrary between the parties. When they in their affidavit, and I say that whether they term it as their opposition, because there is really no allegations made in my application. All that I have sought for is that I do not know, I do not have the partnership deed. It's not
This
possible
court
for
has
me.
directed.
Yes, it's a
Two
pursuant
points,
to
they have
Press
done this. Correct. Now it is your duty. So with regard to the partnership, one partner died,
Yes.
partnership has gone. They have stated that they will reconstitute it.
I'll join
But
issue when the partnership is gone on that aspect. Because I'll tell your lordship why.
so tell me how the partnership continue.
No, my lord, I cannot tell your lordship how the partnership continues, but I can tell your lordship this much, that it's their consistent stand since March 2024 until this day, that the partnership firm was being reconstituted. That's their statement on oath on affidavit. And that affidavit, whether they term it as opposition or whether they term it as something else, is completely up to them. But that statement is on affidavit saying that it is on the it's on the verge of being reconstituted.
Correct.
So reconstitution means they will either take some partner from the legal heirs of defendant number 3, or they will not take, they will take someone completely, a complete stranger to the partnership firm, either or. But this stand, because section 42C says, or section 42 says that it's subject to the contract to the contrary, that means either they disclose that contract or they take a stand now that I have not reconstituted the partnership firm. Section 42C applies, and hence there is complete dissolution of partnership firm. In my respectful submission, if there is dissolution of partnership firm, I'll distinguish these judgments, and I'll tell your lordship why these judgments will not be applicable in this case. Because if there is dissolution of partnership firm, kindly considers a situation. A partnership firm enters into an agreement with a party, takes a loan from any bank. NBFC can be equated to a bank. From any bank, takes a loan. Then one of the partner dies.
So that's why telling where is the partnership, where is the condition, whether in the partnership
So they
it's
can
there, one
disclose the
partner
partnership.
died, one partner died,
They
the
can-
nominee of
Your
the
lordship can
partner
direct them to disclose the partnership deed. It will be evident from there, because it will not.
It's not your case. You have been requested and they have provided.
Your
How
lordship
the
will kindly
court,
see.
how the court can
I
sit
have,
on
what have I requested? Kindly seize my application once. Kindly seize my application once,
Because
page 5,
if-
paragraph
if-
7.
If in the partnership deed there will be a clause. Yes,
That the
one
and or
if
surviving
any of-
heirs.
Yes, heirs or no, or he can independently take the other partners by giving giving all the assets, whatever the shares of the partner. There can be anything can.
Anything can be.
So
Your
that's
lordship
why.
can direct them to produce
How
the
this court
partnership.
can, this court can collect the evidence on your behalf?
Today,
You
your
have not,
lordship,
after the death, you have not made that endeavor. You have not made any endeavor to, yes, please give the partnership deed. What is the condition so that I can
what
take appropriate
endeavor I
decision?
have
Two
made,
line.
I'll tell you, lordship, what endeavor I have made is at page 5, paragraph 7. Kindly seize that. This is all that I could at that point of time come up before your lordship with.
Correct.
Kindly seize that page 7, page 5, paragraph 7. It says defendant number 2, who is the remaining partner of the defendant number 1, is duty bound to disclose an affidavit before this honorable court the names and other details of the partners of the defendant number 1. What they could have done, I'll tell you, lordship, what they could have done.
As well as two partners.
I'll tell you, lordship. Now, defendant number 2 is also a partner to the partnership firm. Defendant number 2 is also the son of the defendant number 3 who has died. So the rest of the legal heirs are definitely related.
How
to
many partners are there?
There were only two partners.
Then
So there were only two partners at the point of time, relevant point of time. And my lord, after the two partners, my lord, I perhaps am not being able to, my lord, express myself. Either, my lord, they ought to have disclosed that none of these heirs are interested to join, and hence the partnership firm is being dissolved. Not that, in my respectful submission, not there. Very well. But they have not
are you?
disclosed.
One of the proposed defendants, one of the legal heirs of
But now-
who are now thought to be added. So in terms of the order of court, I have filed an affidavit opposing the application. In the affidavit, the particular point rightly argued by Mr. Bhutkar. Paragraph 5, I have taken this specific point that one
Very
partner is on record.
Very good.
I am not supposed to be added.
Correct.
And according to order 30.
So that's why, as per your affidavit, you are not been included as a partner.
Correct.
And I am no, don't want
Simply stated, your application is that you have not been included as a partner, so you are no liability on that.
you could provide for the remedy, my management can proceed with that.
This is the
So, my lord,
simplicity.
so, my lord, it is a very interesting case where the partnership firm is there, one of the surviving partner is there, whose brothers and sisters, he's not taking any liability of. They are coming up
No,
and saying
that can
the
be.
partnership firm has
That
dissolved.
can be, but you cannot.
But who will?
You cannot say, "Ki no, I have to be
This has
included."
become like a originating someone's
Ah.
suit. He will ask question to the to give answer.
Answer. So the first
You find your own
first
remedy.
you have to establish. First, you have to establish. Yes, you have a right in the partnership firm, so you have to be included in the partnership. Then, if you have been included, then this suit can continue. Otherwise, you have to take the recourse of the other way.
No, but
See,
I am a bank. I have to recover my loan from someone. And my lord, defend number one.
You are
and
the bank.
I am
You
the
are-
bank. I have to
Second,
recover my loan
and
from
you have
someone.
given the loan to the partnership.
Partnership
the
firm.
bank might have been taken the original partnership deed.
NBFC.
NBFC.
The bank might have been taken the partnership deed without the taking the all details. How you have given the loan?
I am an NBFC.
Maybe.
I am an NBFC. But my lord, I'll tell you, lordship, my lord, they
Favored litigant.
But I'll tell you, lordship, my lord, today it is, my lord, duty bound for them to either disclose the names or disclose, my lord, why they are not disclosing the names and details. At least that
He is
much.
telling that it dissolve. He is telling that 14C dissolve.
This is coming up today before your lordship.
Correct.
That's not
why-
the affidavit
That's why you
from
come.
March
You
2024.
come on that day.
Very well, my lord. Very well. my lord.
You come ready. What
Not
will
any day, my lord, in the coming week, my lord. if your lordship
son suffering for the plaintiff? Sons, you are for the plaintiff.
And for the plaintiff.
And sons
Unfortunate,
suffering
not
for the
All plaintiffs are unfortunate.
Not being able to
Mr.
recover
Post, you
my
are
money.
appearing for whom?
For the second defendant,
Sons
defendant
suffering
number
for the
2.
defendant number 2. And sons suffering for the proposed defendant. Proposed defendant. Full list of counsel for the
affidavit is for 1 and 2.
parties has argued at length, but due to paucity of time, hearing could not be completed. According case is adjourned. Let the matter appear on when?
Not any day, my lord, coming week, my lord.
Coming week 24th.
Grateful.
24th, I hope, is not a Friday.
Take the book.
No, 28th, my lord. Right.
24th.
20. Great. No, 24th.
my application, if your lordships kindly see the summons for direction.
Yes.
Well, there is an account maintained by the official liquidator, that is official liquidator establishment charges account. This accounts is required to be audited. Now there was a direction for audit. So in this application, I have enclosed here with the audited report. And my lord, I am seeking also further audit. My lord, if your lordships kindly see prayer B. Because prayer A, that was with regard to this financial year, my lord, 1st April 2018 to 31st March 2019. And 1st April 2019 to 31st March 2020. These are all, this has been done. Now prayer B, my lord, 1st April 2020 to 31st March 2021. And my lord, the 1st April 2021 to 31st March 2022.
Yes.
So your lordships, I am seeking number A, my lord, that audit report, my lord, which is annexed with this application, may be approved by your lordship.
Where is the audit report?
That is annexed. My lord, page 8. My lord, page 9, my lord. Start from page 9. That is up to the year ended 31st March 2020. Then, my lord, the second, my lord, report starts from page 16. Year ended 31st March 2019.
Cashbook and ledger are not signed by the management at the regular intervals. The maintenance of the ledger book is not satisfactory. The ledger book should be maintained in a manner that total figures should be ascertainable. Book reconciliation statement have not been maintained. Fixed deposit receipt have been physically verified. Considering the value of transaction and in order to bring more accuracy, preparation of account management should go in for accounting software. Yes.
Now, my lord, if your lordships kindly see paragraph 4 of this application, affidavit, my lord, paragraph 4.
Yes.
My lord, page, kindly see there is written the last line. The said auditor in his remarks pointed out the cash book and ledger not signed by the officials as regular.
That's I'm telling that the observation which has been made by the auditor.
Yes, my lord. That with regard to that, my lord, we have prayed, my lord, something before your lordships. My lord, kindly see the book ledger not signed by the officials at regular interval. Maintenance of the ledger book is not satisfactory. The ledger should be maintained in a manner that total figures should be ascertainable at a glance. Bank reconciliation statements have not maintained and consideration to the volume of transaction, and for more accuracy in the preparation of the accounts, the management should go in for appropriate accounting software. as regards the accounts software, official liquidator will try to purchase the same with the approval of the Honorable Court. So, my lord, that is the, my lord, the observation of the official liquidator. They will purchase the software, my lord, required software with the leave of your lordship's court for the rectification of their mistakes, if any, in future course of action. Now, my lord, if your lordship kindly turns to page 16, that is in respect of the year ended 31st March 2019. And they are also, my lord,
the same thing.
Same thing, yes.
Yes.
Same observation. And my lord, the last, so my lord, these are the two.
I am accepting, but I will direct the official liquidator. The observation made by the auditor is to be taken into consideration
My
in
lord.
future.
And my lord, your lordship also kindly record the statements made in paragraph page 4, my lord, the last two lines as regard the account software, official liquidator will try to purchase the same with the approval of the Honorable High Court. My lord, that is the steps to be taken by the official liquidator for, my lord, the observation which has been made by the
Because why the office is not having the system? Why you wanted to purchase a new one?
My lord, as of now, I am told that the system is not there, but they will purchase, my lord, with the leave of your lordship.
Why? Fire and General Insurance Company, India Limited.
Yes. So, my lord, I am praying for, in view of the, I am praying for order in terms of prayer A, B, C, and D. And your lordship kindly grant me leave to purchase the software also, out of the funds lying with the, my lord, the official liquidators establishment
The
funds.
fund belong to whom?
Or official liquidators establishment funds.
Then the official liquidator is not having all the all systems.
Lord, that
He's
is
maintaining so many accounts. Why you want to purchase a new one from this account?
This is the first time observation, my lord, they made by the auditor. So, my lord, accordingly, my lord, official liquidator has prayed also for purchase of that with the leave of your lordship's court. So, my lord, I am seeking in this application, I am seeking, let the application may be disposed of, my lord, by passing the
Because
order.
the official liquidator is holding is one office only.
Yes, only one office.
Not this office in the insurance company.
No.
Correct.
There are so many files, my lord. There are numerous files.
Correct.
At least, my lord, more than 400 companies are there, my lord. So, my lord, and this is the particular accounts which was maintained in pursuance of the order of the Honorable Justice Padda Khastakir Dividend, because whatever, my lord, the sale proceeds, out of sale proceeds, my lord, some interest is being taken in this account, and these accounts, my lord, maintained, and my lord, from the this account, salaries of the all the employees are being paid.
So how you are maintaining all these things?
My lord, as of now, my lord, the observation, my lord, my submission would be, my lord, the observation, taking into consideration of the observation, my lord, the official liquidator already, my lord, they placed before this honorable court, my lord, in paragraph 5, and my lord, your lordships kindly allow the prayers made in prayer A, B, and C, D, and my lord, an extra prayer, my lord, which I am seeking as regards to the account software, my lord, the official liquidator may be leave may be granted to the official liquidator to purchase, my lord, the required software, my lord, as suggested by the chartered accountant, my lord, so that, my lord, the subsequent events can be done on the basis of that.
So what will the cost of this software?
That we have to assess from the market.
Correct.
Yes.
That has to be assessed.
Yes. No, my lord, your lordships kindly grant leave to obtain the, my lord, the quotation, so that, my lord, the that can be placed before your lordships, and then only your lordships grant pass an order, appropriate order.
So and so applying for the official liquidator. Full stop. The official liquidator has filed the report disclosing the audit report for the year
2020, March 2020 and March 2019.
For the year both are March 2019. Kindly come to the page 9.
Yes.
Page 9.
Yes, my lord.
Different payment accounts for the year ended 31st of March 2020.
Yes,
Acha, 2019.
yes, yes.
For the year, for the ended year 31st of March 2019 and 31st of March 2020.
Right.
Full stop. In both the reports, comma, the auditor has made the following observation. Page 22. कर देना. Page 22. यहाँ से यहाँ तक. Full stop. The audit report submitted by the auditor is accepted for the ended year of 31st of March 2019 and 2020. 19 and 20.
And my lord, prayer B, my lord. Further create, my lord.
Counsel for the official liquidator submit that as per the suggestion made by the auditor, comma, the official liquidator is intending to purchase the account software for the purpose of
maintaining the accounts properly.
For the purpose of maintaining the appropriate account, maintaining the account properly. Full stop. Consider the submission made by the counsel for the official liquidator, produced the audit report and the observation made therein, comma, prayer A.
B, my lord, the further, my lord, the
indicated then. Full stop. Counsel for the official liquidator also prayed for an order for leave to get the audited the account of the official liquidator for the year 2021 and 2022.
Yes.
Why not 23, 24?
That I have made another application for
Not
that.
done.
In my lord, second application, my lord, is with regard to that.
2021, 2022. Full stop. Pay the official payment is made? No.
No, my lord. That is, I am seeking, my lord, your lordship, kindly see. First of all, appointment of the empaneled chartered accountant maintained by the Honorable Court. That is in respect of the prayer B. And my lord,
Considering the submission made by the counsel for the petitioner, official liquidator, prayer A to D.
A to D.
A to D is allowed.
And my lord, the leave may be granted to get the quotation.
Yes. As regard the purchase of the account software, comma, the official liquidator is given liberty to call for the quotation to purchase the account software from the reputed firms and to file the report before this court before the on the next date fix. Let the matter appear. How much? 4 weeks?
Yes, 4 weeks.
Let the matter appear on. Today हम लोग कितना तारीख है? 7 तारीख. Let the matter appear on 21st of May 2025.
I am deeply blessed.
क्या हुआ?
Holiday,
Summer vacation.
summer vacation, I don't know.
That is from 24th.
Yes, 24.
23rd is the last working.
Yes, yes.
You want in the month of June?
Lordship, I think it's a June.
Okay, put on 11 June.
I'm deeply obliged.
Next.
My lord, that is in respect of the, this is also an application. If your lordship kindly turns to the summons for direction. My lord, where I have paid for half-yearly, kindly see prayer A. The Honorable Court may kindly be permitted to file the half-yearly statement of accounts under Rule 298 of the Companies Code Rules 1959 of 116 companies under liquidation for a period from 1st October 2022 to 31st March 2024 as per Annexure A and for the period as mentioned in Annexure B and C of this area. So, my lord, there are 116 companies for which, my lord,
How many companies are there in the under liquidation?
Lordship, at present, I think there are 325 near about. More than 100 companies have been transferred to NCLT. So
NCLT. Yes. You may granted to the fairly accounts up to the transfer of companies in liquidation to NCLT.
But here A, B, C, D, and E, my lord. Now, the name of the companies is being is mentioned in the Annexure A, page 7, my lord. Sorry, yes, Annexure A. It starts from.
Acha, all companies.
Yes, yes, my lord. It starts from page 6.
Yes.
These are the 116 companies, my lord.
At the Learned Counsel for the official liquidator. Prayer A2. E. Of the summons
for
direction.
direction.
Summons for direction is allowed.
I'm deeply obliged. I'm deeply obliged.
The official liquidator is submitted to file report by.
My lord, same day, my lord, your lordship kindly.
By 11th May
11 June.
2025. 11 June.
11 June. I'm deeply obliged. My lord, this is my application. My lord, the first application which was, my lord, your lordship was grant, my lord, the audit report accepted for the year 2020 and March 2020 and 2019. 19 and 20. Now here, my lord, I have prayed for, kindly see the summons for direction, prayer B. From 22 to 23 and 23 to 24. That is in respect of the well establishment charges funds, charges accounts.
At the Learned Counsel for the official liquidator. Prayer A2. D. Of master directions. Summons for direction is allowed. The official liquidator is directed to submit the report by 11th
11 June. I'm deeply obliged.
Yes.
There's an application by a contributory for payment. Company was wound up long time ago. I placed certain orders which are very relevant. Only 2 shareholders. Claims were invited. Whatever claims were received have all been settled. Unlike in most cases, substantial sums remain with the official liquidator. in spite of the official liquidator having tried his best to sabotage the case, the property of the company was allowed to be taken over by a third party. It was the contributories who had to bring it to the notice of the court. Contributories, and the property was recovered. All the plant and machinery has gone because the official liquidator did not pay the salaries, all recorded. I'm not saying anything which is outside the record. Now substantial amounts are in hand. This money is required to be disbursed. Share capital was only rupees 2 lakhs. There were only 2 shareholders. The share certificates are on record. They say that yes, we will pay subject to orders of court. I'm here. The entire money is to be paid to me together with accounts because I'm entitled to the entirety of the corpus. I'm here.
Who are you? Who are you?
I'm the contributory, the 100% of the shareholders.
It was declared.
The share certificates are on record.
Declared.
My lord, the share certificates are on record. But the DFC, the website says that the authorized, the paid up capital is only 2 lakhs. They don't dispute that. My lord will take Justice Banerjee's order.
So what is the difficulty now?
Lordship, the situation is like this, Your Lordship. What they have assessed by that is by the dint of the document to the Ministry of Corporate Affairs, that this amount is pending and which are claiming. Lordship, we are seeking to appoint a company secretary just to assess what amount is payable, what is the assessed amount. Because what they are stating, it is their statement. In the reply, they have annexure B, Your Lordship. So to cross-check, Your Lordship, we are seeking, Your Lordship, if my lord pleases, we will appoint a company secretary from our impaneled company secretaries, and thereafter we will come up with the appropriate figures.
All the papers are here, my lord. What will they check? My lord will kindly take page 60.
Yes.
Just take their stand. I didn't want to say things. I will have to say a lot of things. My lord will take the order at page 60, passed by Justice Shonji Banerjee, then presiding of the company court.
Yes.
My lord will come straight to page. This order records the conduct of the field liquidator in frittering away the assets. But other than that, my lord will now come to internal page 12 of the order. Running page 23, my lord takes, and timeline was laid down. Not now, in 2012, 13 years ago. The affiliate liquidator will invite claims from all creditors of the company in liquidation and settle the claims in accordance with law within a period of 4 months from date. The affiliator will thereafter disburse the money received from the 2 allottees to the persons rightfully entitled thereto in accordance with law. The affiliate liquidator should apply for dissolution of the company upon payment being made over to the persons entitled thereto, and within 2 months of its completion of payment by the allottees to the affiliate liquidator. What have they done for the last 13 years? They are sitting on my money, utilizing my money. I'm entitled to the entirety of the money. Nobody else has raised any claim. Whatever claims were raised have been dealt with. This entire money is to come back to me. How can they keep enjoying my money and now say, I'll take more time? What have they done for the last 13 years? They are in contempt of this order.
After 2012, what you have done?
Exactly. Let them say what they've done.
Lordship, in the opposition, after 2012, the details have not been indicated here. If you, my lord, submits, we can file a report. Because your lordship, to start, what has fallen from your lordship, the query that has fallen from your lordship, that has to be satisfied, your lordship. But apart from this, your lordship, in opposition, your lordship, in paragraph page 19, your lordship, the entire detail has been given. But if your lordship pleases, then I can come up with a short history since 2012, what has been done with the property.
No, that's correct. You will not come with what you have done. So how it is to be, because already there is an order.
And my lord,
and you are not challenged this order.
Lordship, we have not challenged, but the point remains is that they have given the accounts. So, Lordship, we can just come up with the, after cross-checking, your Lordship, we can just come up and
They have said on affidavit that they are going to pay. My lord, take page 8 of the affidavit in opposition. My lord sees paragraph 8. In internal page 8, middle of the paragraph. Upon receipt affidavit of claims from the contributories, that is my claim, with a letter number such and such, respondent office duly informed the advocate of the contributories whether dated such and such, that their claim would be acceded to, subject to an order passed by this honorable court. Since they say that they cannot return the money without my lord's specific permission, my claim would be acceded to. That is their stand on affidavit. But what have they done?
Lordship,
and the only thing is they say in paragraph 9, at page 9, paragraph 10, they are the only 2 points that they've said. At page 10, therefore, For showing good intention and gesture, the applicant will pray for appointment of an empaneled company secretary for preparation of finalized initial list. Where's the question of doing this after 13 years? Nobody else is there. The share certificates are on record. Let's see the
Lordship,
share
in my
certificate.
opposition, Your Lordship, we have detailed described in page 4 and page 5. That is internal page 4 and internal page 5 may be permitted to place Roman 5, Your Lordship, in compliance of the aforesaid order.
Yes.
In compliance of the aforesaid order dated 18th April 2012, respondent published claim invitation notice by way of newspaper publication on 3rd August 2012 and 6th August 2012, both in Delhi and Calcutta editions. In response thereto, claim received from Futoba Products Limited of rupees 1,63,000 and odd, and another was Nomura Investment Finance Private Limited of 91,85,000 and odd. After obtaining leave from the Honorable High Court, wide order dated 25th September 2014. That the claims of Putuba Products of 1,63,000 had entirely been rejected by way of rejection notice. No appeal under Rule 164 has been filed, and that the claim of Nomura Investment was entirely rejected by official liquidator upon issuance of notice of rejection under Form 69. Since been defined in the said notice, categorically stating the disputed claim of 1,50,000 is claim of amount prior to incorporation of the company in liquidation.
These have all happened 10 years ago.
No. The question is what the status, what the functions or the role of the official liquidator since 2012. So that is the description or details which has been indicated here. That it is evident from the affidavit of proof of claim that the said Nomura Investment is a assignee of the contributory and not a creditor of the company. Official liquidator invited the claim by way of the paper publication but couldn't disburse any amount to the persons rightfully entitled to in accordance with law. Needless to mention, that's a Nomura Investment, upon obtaining leave for delay in making or submitting affidavit of proof, wide order dated 25th September 2014, furnished the requisite affidavit of proof date on July 1st, 2014, quantifying the claim of rupees 91 lakhs and odd with the official liquidator. The claim itself showed principal claim of 1,50,000 and residual part indicates an interest accrued on the principal. That being aggrieved and dissatisfied with the decision of the official liquidator upon the notice of rejection dated 31st July 2017, said Nomura Investment filed an appeal under Rule 164 of the company's rules 159 upon 1959. Upon hearing of the said appeal on 11th November 2021, this honorable court was pleased to direct for filing a status report bringing on record the status of the liquidation proceeding of the company, which was returnable on 13th December 2021.
So what has happened to the claim of the Nomura?
Nomura's claim has been rejected. Nomura's claim has been rejected.
No, this second one?
There were two claims.
Yes,
One is Fotuba and one is Nomura. Both the claims has been rejected, which has been indicated. We have all stated in our opposition, Your Lordship.
What have they done thereafter? Have they paid me?
By a
From
letter,
the order of the
by an order dated 9 September, this court has directed to consider the.
Lordship.
After rejected again.
We are not against the payment, Your Lordship. We are just, my humble submission is that people just want to cross-check the amount, what they are claiming. That is the only.
How soon you will do?
Lordship, 4 weeks, because this will take some time, Your Lordship.
My lord, this is, my lord will see that conduct. My lord will take page 58.
A very simple and short
The
prayer, Your
official
Lordship.
liquidator cannot say that till today I do not know what the share capital is.
58.
Now take page 58. Only two shareholders. Both the share certificates are on record. At page 58 and 59.
Ashok and Arun.
Yes. Family-owned company. No, nothing payable to any outside. The entire money has to come back to me.
10,000.
They just keep enjoying my money for the last 13 years.
10,000 each.
Exactly. 1 lakh each.
No.
1 lakh shares.
No. Number of shares.
Number of shares is 10,000.
10,000. That's right.
Number of shares is 10,000. And my lord.
Let us come back on the next date. I'll satisfy Your Lordship whether his claim is absolutely, Your Lordship. That we will pay. We don't have any.
Why not
difficulty.
today? What were they doing?
There is no difficulty, Your Lordship.
The difficulty is that there is an order asking you to do something within a particular time, and which you have not done.
I am passing an order directing you to comply with the order within a week and to file the
Within
report,
a week, my lord.
File the report on next. Today we are on 17 and 16. File the report on 30th.
Lordship, compliance. Regarding the compliance means that we have to pay.
Absolutely.
Correct.
That is the order.
Regarding the cross-checking, Your Lordship, that remains.
2012 onwards.
They haven't done it in 13 years. They won't do it now. And I will have to go in why they have not done it. The record. extraneous consideration.
2022, you have decided the other two claims who have came before you. You have decided and you rejected. So nothing else.
That is there, your lordship. But the point is the amount that they are claiming, your lordship, justice, at least for the ends of justice, your lordship, at least
The
2 to
entire
3
amount
weeks.
with
What
accounts.
I understand. I understand the delay might have been caused, your lordship. Just 2 to 3 weeks, my lord.
3
I'll come back.
weeks.
I'll come back, your lordship.
Will a client personally pay interest out of their own pocket for these 3 weeks? It's a substantial amount of money. 90 lakhs or not. The entire amount with interest is in any case receivable by me.
So suffering for the petitioner, a company in liquidation. Now, company in liquidation is not here, no?
The company in liquidation is represented by the free liquidator.
Liquidator. So suffering for the applicant petitioner. So suffering for the official liquidator. Police up. The petitioner / applicant has filed the present application, praying for a direction upon the official liquidator to issue dividend of the surplus amount to the contribution in terms of the affidavit of claim filed by the contributories, being 100% contributories of the said company in liquidation, along with the interest accrued therein.
And along with accounts.
Police counsel for the
Accounts are very important.
/ applicant also prayed for a direction upon the official liquidator to provide the accounts of all the creditors' claims settled by the official liquidator in the present case. Full stop. Counsel for the applicant has relied upon the judgment passed by this court dated 18th April 2012, wherein this court has passed the following order. Page 71, last this one. Full stop. Counsel for the applicant submit that in spite of the specific direction passed by this court, till date the official liquidator has neither released, has not complied with the order passed by this court dated 18th April 2020.
No filed an appeal therefrom.
Full stop. Counsel for the official liquidator prays for 3 weeks time to settle for settlement and adjudication of the claims in accordance with the prevailing law. Police counsel for the applicant raised objection and submitted that there is a direction passed by this court. Only the official liquidator has to comply with the said order, but in spite of the same, the official liquidator time and again taking time from this court instead of comply with the order passed by this court. Consider the submission made by the counsel for the respective parties, this court direct the official liquidator to comply with the order passed by this court dated 18th April 2012 by
23rd.
Lordship, 23rd will be a very short date. 23rd will
by
be.
You just draw a
by
check.
issuing dividend of the surplus amount to the said contributions in terms of the affidavit of claim filed by the contributories, being 100% contributories of the said company in liquidation along with the interest, as well as to provide accounts of all the creditors' claims settled by the official liquidator within a period of on or before 7th of May 2025 and file the report before this court on 14th of May 2025. Let the matter appear on 14th May by filing report by the official.
My lord, cut it shortly. Instead of giving 3, give them 2 weeks.
Lordship, will
See,
take
you
some time
want
because there's a holidays in between.
come because there are 3 holidays. All these things are there.
I hope to get the payment before the vacation at least.
That's why I specifically directed let come.
I didn't place the order. If my lord goes through the order, man will be shocked at the conduct which has been held by Justice Banerjee.
But that's why you slept over from 2012 till date.
I've been the person who's been taking steps at every stage. I've been the person. The entire plant and machinery has been sold. Why? Because they refuse to pay the security guard.
By 7 they will give. On then 14 they will file the report. Let them pay.
I'm obliged.
Lordship, item number 5, Your Lordship, this was an application for dissolution, Your Lordship, wherein the auditor has already been appointed pursuant to Your Lordship's direction. So, Lordship, I'm just praying for 4 weeks' time to file the auditor's report. Auditor's report has not yet been received.
So and so appearing for the official liquidator. Counsel for the official liquidator prays for 4 weeks' time to file auditor's report. Consider the submission made by the counsel for the print official liquidator. Case adjourned. Let the matter appear on 7th. No. Let the matter appear on 14th May for filing audit report, auditor's report by the official liquidator. For filing auditor's report.
इसका तो हमको time.
Next.
Lordship, item. Huh?
PS6 नहीं item 6.
PS6.
कागज नहीं है इसका नजर.
Yeah.
Lordship, I'm just praying for a week's time because today I'm a bit handicapped.
Have you served the copy? Report?
Copy has been served. They have filed the reply also.
Yeah.
Item
But
number
with
6
respect-
is our application for dissolution, and 7 is their application.
7 is my application not with respect to Lord disbursement of the surplus amount, admitted surplus amount that is with them. Lord, in 2010 there was a publication made by Lord inviting Lord contributories or creditors, Lord, whoever want to take the surplus amount. Lord, that we came to know recently and immediately we lodged that claim. Lord, they said go to court, get an order of extension, we'll do whatever is required. Lord, we came up before this court by filing this application. Now, in this application, Lord, here they say that I have to prove my heirship and I have to file necessary documents. Lord, whatever documents we had to give, we had already given. We had also asked to specify what extra documents you want.
Let the verify come within after 2 weeks.
Lordship, we will come back.
Lord, only one thing. Lord, there was Lord, may I file the affidavit in reply?
In J6, CS6.
CS7.
CS6 is our application for dissolution.
Item number 6 and 7. Lord, 6 is CS6 and 7 is CS7.
So and so appearing for the petitioner. So and so appearing for the official liquidator. As per the prayer made by the counsel for the office and counsel for the petitioner filed affidavit in reply in connection with CS7 of 2024. Let the same be kept with the record. Counsel for the official liquidator prays for time to verify the records submitted by the petitioner. In view of the submission made by the counsel for the official liquidator, case is adjourned. Let the matter appear on 7th.
7th of May. Lordship, if it is on 14th of May, it will be better.
Matter appear on 14th. 6 and 7 both, huh? 8.
Lordship, in this matter, I am appearing on behalf of the official liquidator, Lordship.
My application.
Kole Biscuit Company.
Yes.
This is my application for recalling of an order.
Before
by
my
which, the official liquidator was direct.
before my learned friend proceeds, my lord.
I would like to intervene in the matter because, my lord, my learned junior, Mr. Induri Nondi, is there before your lordships. Now, we are the affected persons against whom we had filed an application which is being parted before Justice Shogoda Bhattacharya Mojumdar. Now, my lord, the applicant before your lordships has filed an application knowing fully well that his matter is parted before the other
Not even
court.
started.
They may not start. They have not served as a copy. They have not even served as a copy, knowing fully well that we are the merchants on the basis whereof the entire matter is being heard by this court. But may I please be permitted to intervene in the matter because the matter has already been heard on several occasions in their presence and also in their
So it is
absence.
a parted matter, then I will release the matter.
Well, the main application is a parted, my lord. May I place the order?
Yes.
CA, my CA. They are so apni to it is-
Lordship, see the order dated. My junior will hand over the copy of the order. 6th February.
My lord, they are praying for a recalling of an order passed by
This
Justice
is
Mojumdar
not parted.
in an application which is parted before Justice Mojumdar.
That is a CA20.
CA20.
Yes.
That's
Mine is
my CA.
CA21.
Yes.
What is that CA21? Who has filed
CA21 is
CA21?
their
My
application.
application.
Is your application?
Yes, for recalling of an order passed in CA20.
And there, my
Yes.
lord, we have not been served.
So we have not been served also.
So both application has to be heard by the His Lordship.
Yes.
So I am transferring it.
Maybe done.
And releasing it. You mentioned.
I do
before.
not have any.
Yes, Lordship, can it assume? Either your Lordship shares or the other the
No,
other.
once
Honorable
the
judge
part head is there, then this court cannot.
Yes.
So and so offering for the applicant.
Lordship, I appear for the defendant number 2 in this, Your Lordship.
So and so offering for the respondent number 2. So and so offering for the.
There's no respondent number 2 in this application. It's only the official liquidator is the only respondent.
In which application, madam, you are appearing?
Lordship, I'm not in that application. I apologize. It was another application.
So in this 21 you have filed.
Yes, 21 I have filed. The official liquidator is the only respondent.
So and so offering for the applicant. So and so offering for the official liquidator. Full stop. Counsel for the and Mr. Dasgupta is
Mr.
Kundu.
Yes.
He's appearing for.
Lord,
I'm
Kole
appearing
Properties,
for the
Kole
intervener
Properties
and
Private
the
Limited.
applicant.
So and
But the
offering for
applicant
the
is
interview.
CA20.
So and so offering.
One of the respondents to the auction purchaser on source data system.
But there is only one respondent. They may be appearing in the other applications.
20 yes. So offering for the intervener. Full stop. The counsel for the intervener has handed over the copy of the order passed by His Lordship Justice Sugato Majumdar, dated 26th of February 2025, wherein His Lordship has kept the hearing of CA 20 of 2014 as parted. Full stop. It is fine from the record CA 21 of 2025 filed by the applicant is also connected with CA 20 of 2014. Accordingly, this court release the CA 21 of 2025 with the liberty to the petitioner to take appropriate steps to place the matter before His Lordship.
I believe the matter will have to go before the Honorable Chief Justice for assignment before His Lordship.
That's why I not directed to take appropriate stuff I recorded.
His Lordship. Deeply obliged, my lord.
Great.
Lord, I am for the official liquidator.
Yes.
My lord, in fact, my lord, the briefs were given to me just today, and I have found that a status report was filed. My
Status
lord,
report is filed?
Yes, status report in respect of the Bengal animal, my lord, that is in terms of the order dated 18th February 2022.
There's no report. Huh? Is there any status report on record? No, Bengal animal.
My lord, there are two matters. My lord, if I may say so, my lord, a winding up order was passed on the basis of the company petition.
Which matter you are arguing?
Item number 9.
Item of CA number. What is the case number?
My lord, CP number 336 of 1982.
This is. It is the BIFR 95.
Yes, my lord, kindly hand over, give me the, my lord, I am saying so, my lord, because CP number 336 of 1982, in which winding up order was passed first.
Correct.
So subsequently, my lord, the BIFR, though recommended the company for liquidation, but that order cannot be passed once the winding up order already passed in CP number. So that
have you
is
challenged that order?
No, there are two, my lord, there are two proceedings. But if a winding up order is being passed in a CP number 336, my lord, this order was passed, winding up order was passed, my lord, 20th June 1984. In CP number 336 of 1982. winding of order was passed. And the recommendation of the BIFR is, my lord, subsequent thereto. So that is the reason for which that recommendation is pending, because company has already wound up by virtue of the order of this honorable court. Usual course, my lord, if BIFR recommended for a company in liquidation to the court, to the Honorable High Court, and Honorable High Court on the basis of the recommendation was pleased to pass an order for winding up. If that being so, then my lord, the number of the company will be BIFR number so and so, so and so. But if the company's order, winding up order is being passed on a company petition, then my lord, the CP number is being there. CP number 336 of 1982. In the instant case, my lord, I understand from the records that winding up order was passed on 20th June 1984.
No.
In CP number 336.
Certified copy of the order dated 12th October 1992 recommending winding up.
Yes. So
under
kindly
section
see
20.
when the winding up order was passed by this honorable court. By this honorable court, winding up order was passed 20th June 1984.
That order is you are having.
My lord, that is not with me, but my lord, this status report, my lord, which I am having, my lord, the status report, and on the basis of that.
Because 1984.
Yes, my lord, this is the, my lord, dear lordships, kindly see the first paragraph.
Where is the order? There is no order.
No, but my lord, your lordships, kindly see, this is the order, my lord, passed by this honorable court on the basis of that referring the said CP number. And subsequent thereto, my lord, all along, my lord, that CP number is continuing. My lord, there are so many orders. If your lordships kindly see the orders. All along, my lord, the order was referred CP number 336 of 1982. So your lordships kindly.
So you do one thing. All the order you come with the compilation. That will be better. Otherwise, it will be again the
No,
future.
your lordships can, my lord, your lordships can record an order that since the winding up order was passed prior to the recommendation of
So
the
that's why I
BIFR.
wanted to see where is the winding of order.
Very well, my lord. I'm
This record.
Right.
There is a pen writing.
Right.
Pen written.
Right.
Certified copy of the order dated 12/10/1992 recommending winding up.
Yes.
And you are telling that 84 winding order is passed.
Passed by this honorable court. Right.
So how this
Very
has
well,
come?
my lord. I shall, my lord. I shall.
So
Yes.
you come with all the
orders.
Compilation.
At least, my lord, winding up order. So
Whatever
that
it
one
may
can
be.
understand that winding up order
When
was
the
passed.
winding
Yes.
of order was passed.
Yes.
If the winding order is passed,
Yes.
so there nothing remains.
Nothing remains. My lord, this my lord, recommendation will not, my lord, they carry anything.
Cannot.
Right. Very well, my lord. Kindly keep this matter.
So and so appearing for the official liquidator. Full stop. Counsel for the official liquidator submit that this court has passed an order for winding up by an order dated on.
My lord, I have given, my lord, the status report, the first paragraph. 20th June.
On 20th June 1984. 84. In CP number 336 of 1982.
Yes.
Full stop. This court did not find any order of binding up dated 20th June 1984. Full counsel for the official liquidator further submit that after the order of winding up dated 20th June 1984, a further order is passed for recommendation of
BIFR for winding up, my lord, does not arise.
Again, an order was passed. Again, a recommendation order was passed.
My lord, this is the notification, my lord, I am handing over, my lord, the order of this honorable court. This is the notification regarding the winding up order.
Correct.
Yes.
क्या बोला? नहीं ऊपर से पढ़ो. Passed an order of winding up dated 20th June 1984. 99, but the said order is not on record. Full stop. But the said order is not on record. Full stops. बाकी कर देते. In view of the above, the official liquidator is directed to file the compilation of the orders.
File a report, my lord, compiling the orders.
File the report by disclosing all the orders, including the order of
winding up
dated 20th June 1984, within a period of
2 weeks, my lord.
2 weeks. Police, let the report be filed on 7th May 2020.
7. I'm deeply impressed.
Keep this,
Yes.
otherwise it will go again.
I'm deeply impressed.
Lordship, in this matter, I am for the official liquidator, Lordship, pursuant to the direction of the order dated 5th February 2025, we have appointed a auditor, but Lordship, what the problem that auditor has been appointed, but he has not filed any report till date. Let the report be come, Lordship.
When he was appointed?
18th February. Lordship, there is a letter, Lordship, if your Lordships kindly see. Actually, this matter relates to dissolution of the company. No claim, no security.
Nothing, no.
Nothing.
Publication is made.
Yes, Lordship, everything is
Nobody has
made.
come for any objection.
No assets, no secured cater, no claim received. Lordship, we have made a paper publication, everything was done.
So and so appearing for the official liquidator. He submits that in terms of the order passed by this court, the official liquidator has appointed the auditor, but the auditor has not submitted a report. Accordingly, the official liquidator prays for time to file the auditor's report. In view of the submission made by the counsel for the official liquidator, case is adjourned. Let the matter appear on 14th
May, Lordship.
14th May for filing auditor's report.
And item 11 is my application. Now, there was an order of 5th of February when this application was moved. Now, this is an old winding up petition filed by Reserve Bank of India against my company. Winding up was allowed. Thereafter, an appeal was preferred. In the appeal, the winding up order was stayed. But my company was doing an NBFC business without a license. So the High Court appointed a special officer, and we were collecting deposits from various depositors illegally. So the High Court appointed a special officer, directing the special officer will collect all this money and disburse to the public depending on that, after scrutinizing their accounts. So appointment was done. The special officer is a ex-retired judge of this Honorable High Court. Now he has disbursed money. He left with some money with him, around 56 or 70 lakhs of rupees with him, apart from his remuneration, and he wanted to pay off the balance. So to the depositors, because the appeal court said you pay off the small depositors and then remaining money will go to Reserve Bank. That was the order of the appeal court. Now the small depositors has been paid off. Now the special officer said, I'm still holding money. What is the use of giving it to the Reserve Bank? I can pay off to the big depositors because it's public money end of the day. So on a pro rata. So that is the reason we came before this court. On the first day when it was moved, Justice Mujumdar, the difficulty we faced is the appeal court said that the balance go back by. So the single bench said,
How it can be modified?
I can be modified. That is a constraint what the single bench faced. So the order of 5th of February records this, that so we prefer an appeal from this order. It has to be, I can't go to appeal court otherwise. So we prefer an appeal. Today morning only the appeal was heard in the first half. It was allowed. And we have been granted liberty, the special office has been granted liberty to pay off on pro rata basis to the big depositors. So if my Lord's pleasure, I can put this order 2 days time I require to place this order.
And keeping next week.
My Lord. So, and this can be disputed, this order as
The order is then
yes, it's next week.
infectious. As per the so and so appearing for the company, nobody is for the RBI.
Reserve Bank, Mr. Kundu was appearing then before that court, I mean, is left.
As per the prayer counsel for the company submitted, the appellate court has modified the earlier order, and he will place the said order by the next week fix by before this court on the next date fix. Let the matter appear on 23rd.
23rd.
April.
23rd, second of April.
Well, my lord, I appear for the joint special officer, my lord, in this matter. Rehabilitation.
হ্যাঁ
the
কিন্তু তো rehabilitation নয়
no,
না না এটা তো আসছে
I'm just pointing out there was one application which your lordship has taken up last week, where your lordship has directed the matter to appear on next Wednesday, my lord, for the joint special officer to be present in court, my lord. I'm just indicating that that order is there and the matter has been made returnable on the next Wednesday. So if your lordship, my lord, well, just to bring to your lordship's notice, my lord, these are other applications. The application was the application which your lordship has kept it for next Wednesday is for the discharge of the receivers, because they have filed an application for discharge of the discharge.
Now, where is the special officer?
My lord, they have been directed to be present next Wednesday. my
That's a separate application
That's a
altogether,
separate
your
application.
lordship. That is not in the list.
So what
of
is
the
this application now?
Lordship, this is CA 58 is our application filed at the behest of the official liquidator seeking leave to disburse an amount of 4 crore 62 lakhs to the Ministry of Defense. Because they are the unsecured creditors, your lordship. They place the claim, your lordship. That is the reason, your lordship, we are seeking leave to disburse the amount in favor of. That is the only prayer in this application, your
Yes.
lordship. That is, he is
You are not aware.
He is not party into it.
I've just pointed out your lordship has indicated the
So how this amount has come?
Lordship, the claim that they have submitted, your lordship, pursuant to that, your lordship, if my lord pleases, then we have to give the detail out.
Details you have to give, because the 4 crore
Lordship,
is
I'll
there.
come up with the details, your lordship.
Since appearing for the official liquidator. As per the prayer made by the counsel for the official liquidator, the case is adjourned. Let the matter appear
2 weeks, your lordship.
on 7th May.
7th. Lordship, 13 is the application of the secured creditors, your lordship. They have not appearing, your lordship. We have filed the compliance report also, your lordship, because they were seeking for payment of 45 lakhs and not for their towards their claim that we have disbursed. The compliance report we have already submitted earlier. CA 64.
Yes, 64. Who has filed? You have filed.
That is the application by the secured creditor.
Secured creditor. They are not appearing.
They are not appearing because their claim has already been complied.
Settled.
We have filed the report also before, your lordship, to that effect. Security agencies. Security agencies.
Where is the report? Report is there.
Reportটা তো জমা হয়েছে. Lordship, in 26 February, the report has been submitted, your lordship. That is indicated in the order itself. रिपोर्ट का कॉपी आज मेरे पास नहीं है.
So you are having now 5 crore 73 lakhs.
Lordship.
So what is the prayer now?
Lordship, this was their application. So this application may be dropped. That is my so far
Nobody is
as
appearing.
64 is concerned, your lordship.
Nobody is appearing.
So subsequently, lordship, we will come up with separate application if we seek for any other.
Since appearing for the official liquidator, none appears on behalf of the applicant. Police. This court find that the matter was taken up for hearing on 2nd April 2025. On the said date also none appears on behalf of the applicant. Considering the above, the CA 64 of 2024 in CP 525 from 2005 is dropped.
Correct.
But in 14, my lord, the last I am for the intending purchaser, my lord.
Lordship, in this matter, I am appearing on behalf of the official liquidator, Lordship.
But on the last occasion, the matter was taken up and I did not appear. I have made a request to the official liquidator to give us a copy of the CA 26 and CA 27, your lordship. What happened, my lord, that I have deposited rupees 21 lakhs. I have deposited rupees 21 lakhs approximately for the purchase of one of the scheduled land. To my instruction, my lord,
Let them write a letter to the official
I have,
liquidator.
my lord, I have. On 10th of April, your lordship, when the matter was taken up on the last occasion, I have made a request to the
In
official
that event,
liquidator.
if your lordships kindly adjourn the matter, so that
Give
on
the
the next
copy.
date. Yes.
26, 27, both.
Yes, your lordship, both.
27 is there.
Yes,
Yes.
item number 15, your lordship.
27 is
Then let
Ah.
this matter be appeared on. কবে লিখেছিল তাহলে?
10th of April, আপনাকে ওটা
Yeah.
আপনাকে দিয়েছিল আপনি লিখে দিতে পারেন।
So and so appearing for the official liquidator. You are for the petitioner.
I'm for the intending purchaser.
Intending purchase. So and so. What is the name?
Noni Gopal Mondal, your lordship.
Intending purchaser.
Noni Gopal Mondal, your lordship.
So and so appearing for the intending purchaser, namely Noni Gopal Mandal.
Mondal, yes, your lordship.
Mandal. Police. The counsel for the intending purchaser prays for a direction upon the official liquidator for supply of the copy of the application along with the documents in connection with CA 26 of 2024 and CA 27 of 2024. In view of the above, the counsel for the official liquidator is directed to serve the copy of the application along with the document of 26 of 2024 and 27 of 2025. 24, 25, to the intending purchaser within a week.
Yes, lordship.
Within a week from date. List the matter on 14th May.
Much obliged, lordship.
Next.
Lord, I am for the official liquidator. May I submit the report? Lord, if your lordship kindly turns to page 3 of the report. But here, my lord, the property was tried to be sold. Initially, my lord, the valuation was not appropriate. That is the reason for which this valuation report was rejected by the Honorable Court. And subsequently, paragraph 6, my lord, I have mentioned, 21st January 2025 was pleased to direct the official liquidator to publish sale notice once in Bengali and once in English daily, well circulated in this state. The advertisement shall be published within 1 month from the date. Accordingly, the official liquidator published sale notice on 13th February 2025 in the said Times of India in English and Bortoman in Bengali, fixing the sale date on 26th February 2025. Lord, the valuation was also done, but unfortunately, the sale date was fixed on the 26th February 2025.
Correct.
But the sale could not be taken place due to want of bid.
Want of?
Bid. No bid was, my lord, the receipt. So, my lord, I am seeking, my lord, the...
So, after publication, nobody has come?
Nobody has come.
So, what you will do now?
My lord, kindly see page 5, my lord, the order passed by this Honorable Court. And, my lord, then, my lord, the page 7, my lord, the publications made therein. Everything was there. My lord, page 9, my lord, there.
Reserve price 13.97.
Yes. But no offer was received.
But is this a land or factory?
It's a land.
Land.
Yes.
Land now nobody is coming. Where it is situated?
No, I am also surprised that it is Newton. Yes, Hatiara.
Hatiara Newton nobody is coming.
But
it's surprising.
Right.
Is the vacant or the tenant?
No, not tenants. There is no tenant, my lord. But, in that view of the matter, my lord, I am seeking that your lordship kindly grant leave to the official liquidator to make a fresh publications.
Which paper you have published?
My lord, that was in written
Times of
in
India and
yes,
Bangla?
and
Bardhaman?
Bardhaman.
So what will do?
If your lordship suggest any other papers, my lord, that can be done. Times of India, better. The Times of India is better.
Times of India, that's it, both are better.
Yes.
What is the valuation of the property?
My lord, that is mentioned in page 3, my lord, 13,97,000. My lord, annexure A, my lord. No, sorry, that is the mentioned here in 13,97,000.
13 lakh 90. Yes, 13 lakh 90. Reserve price.
Yes.
What is the area?
My lord, the area is, yes, my lord, it is mentioned.
Pursuant to the situated register village. Sir, you have published the notice. Where is the survey number, plot number? Kindly come to the notice. Office come registered office come factory
My lord,
premises.
it is in the terms and condition, my lord, page 11 onwards.
Where is the description?
Description of property.
Kindly come to the page 8.
Yes.
Paper publication.
Oh, my lord, I'm sorry, only movable assets. Only movable assets.
Movable assets.
Yes, not the, my lord, the immovable.
What is the only?
My lord, page 18, my lord, kindly see. E-auction events, my lord, was there.
Page 18.
Page 18 and 19.
Where is it? Immediately after. Where is the description? Payment schedule. Where is the description?
It is in the, my lord, in the page 9, my lord, only saying that location, address of movable assets, property of the company.
Correct. What is the movable assets?
Plant and machinery and structure.
So you are not mentioned. Kindly come to page 9. Location, address of the movable assets property, registered office come factory premises.
Yes, sir.
What is the property in liquidation? Where is the description in the original file? You have to see that. What are the property? What the factory? Because it is some address and all these things.
My lord, the valuation report is lying with your lordships. Well, then that will be, that may.
No, valuation report is okay, but in the
in the valuation report, my lord, the description of the mobile assets must be there.
the valuation report is there. Chaudhary Packaging Private Limited.
Yes.
Not mentioned.
Valuation nahi.
Messrs. Chaudhary Packaging Private Limited in liquidation, PS so and so so and so. Official liquidator, description of the properties. That's why kindly come. You're not having that.
No, my lord.
Property comprises of a doctor's factory, or might be factory shed having an area of 4382 square feet and a
Yes.
structure and a piece of land which are not belonging to the aforesaid company.
Yes.
The factory shed has been constructed with the asbestos sheet so and so so and so. The floor ordinance so and so so and so. Plaster so and so so. There is also a RCC Pakka structure having 242 used for drawn room and the RT tiles on the 82 square meter bathroom so and so so and so. So 482 square feet, the 32 lakhs extra cost Pakka. So total 5 crore 2 lakhs 5 lakh 2,550. Plastic container and all these things. So you have to publish this total.
My lord, the next publication, if it is done, my lord, definitely disclose the entire things.
So what I am giving the copy of the you are having the audit report.
Not I have got the audit report, but my lord, unpriced.
So I am giving the copy of the report. You go through, but the publication has to be made as it is. What are the description
Yes,
of the
my lord,
property?
definitely.
Because
definitely.
if tomorrow the other
Right.
what will say that the person who is ready to purchase all these things, they can come.
My lord, your lordship is absolutely correct.
So and so appearing for the official liquidator. Full stop. The official liquidator has filed the report wherein it reveals that in terms of the order passed by this court, paper publication were made for sale of the property, but in spite of the paper publication, none of the person has come to purchase the said property. Full stop. This court has gone through the paper publication and found that though the paper publication has been made, but the description has not been given properly. Description of the property which is to be sold has not been given properly. Full stop. In the open court, the valuation report submitted by the auditor and the valuer is open, and wherein it is found that the valuer has given the total description of the property in his valuation report. Full stop. The office is directed to serve the copy of the valuation report to the learned advocate for the official liquidator. Full stop. After receipt of the valuation report, the official liquidator is directed to publish a notice of sale of the property which has been described in the valuation report in the English daily newspaper, the Times of India, and Bangla newspaper, Vartaman. And by fixing the
Times of India
basic price of rupees 13,97,425 as per the valuation report, and to file the report before this court within 4 weeks from date. Let the matter appear on.
Lord, your lordship, kindly fix the date of sale.
Because the official liquidator shall fix the date of sale on sale of the said property on. So when you will publish, how much time you will take? 2 weeks.
Within 2 weeks, we will publish the this sale notice.
So the sale date is fixed on 6th May. It will be done. The official liquidator, by publishing the notice for sale of the property, the date of the sale of the property shall be fixed on 6th of May 2025 at what time?
11 to 5.
11:30 a.m. 11:30 a.m. Let the report be filed on 14th of May 2025. 11th of 11:30 to 2 p.m.
No, 5 p.m.
to 5 p.m. 11:30 p.m. to 5 p.m.
Through the क्या?
E-auction.
Through the e-auction, through the e-auction.
To e-auction.
I'm deeply impressed.
Next.
My lord, here, my lord, I am for the official liquidator. My lord, in this matter, valuation is lying with your lordship's officers. And on the basis of the valuation, my lord, I am praying for prayer A, B, and C. And D also.
Conduct e-auction.
Conduct e-auction. Your lordships kindly turns to affidavit, my lord, in support of the summons for direction, page 4. Page 4 and 5, my lord, there are 5 immovable properties, movable and immovable properties.
Affidavit?
Yes, affidavit in support of the summons.
4 and 5.
In a paragraph 5, my lord, kindly see paragraph 5.
Yes.
The details of the, my lord, the movable assets.
5 properties.
Yes, 5 properties are there. So out of which, my lord, I am intending to sell, my lord, the 2 flats, movable assets 1 and 2. Item number 1 and 2. If your lordships kindly see the
Possession of
summons.
movable assets,
Yes.
furniture, fixtures, laying the registered officer, Lenin ceremony.
Yes.
And possession of 2 flats as movable assets in furniture, fixtures.
Now, if your lordships kindly turns to summons for direction prayer A. I have stated so. But the Honorable Court may kindly grant leave to the official liquidator Calcutta to conduct e-auction through Railtel Corporation of India Limited, designed auctioneer as per the guidelines and Ministry of Corporate Affairs of the immovable properties, that is 2 flats situated at Mauja, Chaubati, PS Sakrail, District Howrah, and the office furniture and fixtures lying at 156A Lelin Soroni, Komalalaya Center Room, number 502A, 5th floor, Kolkata 7 lakhs 13, respectively, as stated in para 12 in support of the affidavit. Now, there are 2 valuation reports annexed therein.
Yes.
Paragraph 12, my lord, I have stated so that Mr. Basudev Dev, valuer, submitted 2 price valuation report in respect of the mobile assets, furniture and fixtures lying at 156A Lelin Soroni, Kolkata, and 2 flats and mobile assets situated at Mauja, Parda, Howrah, mentioned to register original site, High Court, Calcutta, and also submitted unpriced valuation report. We are having the unpriced valuation report, but your lordships is having, my lord, the original valuation report. So reserve price is required to be fixed, and my lord, then in terms of prayer A, B, and C.
So, as per this, 46,450.
Yes.
And another is
Valuation to late 46 lakhs. No.
8,700. Fair market value 74 lakh 60,000.
Distress price possibly there.
So this one report is with regard to the valuation report and valuation certificate. G+4 story northern side, version is so.
But one valuation report in respect of the immovable properties and the second valuation report in respect of the movable assets.
Immobile property, that is the total price is 74,60,000.
Yes.
Fair market value.
So that should be the reserve price.
That should be reserve price.
Right.
And with regard to the other, this. No, in that also, furniture is also there.
Yes, Malad, the details of the furniture also mentioned in internal page
9.
556, internal page, Malad, in the valuation report.
Of 8,700.
Yes.
Light, switchboard, table, and all these things. And second one is only the movable property.
Yes.
$46,40,000, 46,450.
Yes.
Total 45 items. So what is your prayer? A.
Malad, the first prayer would be, Malad, as requested by the official regulator, let a copy of this valuation report be handed over to the official regulator to make it easy for the purpose of. Then, Malad, the prayer A, definitely prayer A, B, and C. And D also. Yes. Reserve price already fixed by this HON'BLE,
So appearing for the official liquidator. Full stop. Valuation report is open in court and found that valuer has filed two valuation report. Wherein in one valuation report, the fair market value of the property is shown as 74,60,000, and the items available in the said property and the value of the item available in the said property is shown as 8,700. In the second valuation report, the valuer has stated that only movable properties, that is the furniture and fixtures, are there, which is totally and fixtures are there, and the total cost of the set furniture and fixtures is rupees 46,450. Full stop. Let the valuation report be, copy of the valuation report be served to the official liquidator. Full stop.
I am seeking order in terms of prayer A, B, and C. And your lordships already fixed the reserve price.
Full stop. This court find that full stop. Considering the submission made by the counsel for the considering the valuation reports and the submission made by the counsel for the official liquidator, prayer A2 C.
Yes.
Of the summons for direction is allowed. Full stop. The official liquidator is directed to submit the report before this court within 8 weeks.
8 weeks.
Within 8 weeks. Submit the report on 11th of June 2020.
I'm deeply impressed.
So this is a report for dissolution. We have filed the dissolution application some other companies in 17 companies, and they are listed. They will appear on the list of 14th May. So it should also be come on 14th
May.
Yes, Lord.
As per the prayer made by the official liquidator. As per the prayer made by the official liquidator on 14th May. Next.
I appear for the applicant in
For the official liquidator. Previously, there was we have filed a report, a supplementary affidavit also. In this regard, the property, immobile property which were under the possession of the official liquidator, that property not belongs to the company in liquidation because it was a leasehold property and lease expired before the winding up order was passed. So, my lord, there was an application for dissolution for handover the immovable properties, my lord. The court was passed an order, and there one secured creditor is there. According to them, though, my lord, my learned friend will say that they have succeed in a case where their claim has been determined by this court, but that order was challenged by the secured creditor. That is pending. Now, my lord, now it is up to them to ask.
My lord, first and foremost, my lord, directed us to take instructions. My lord, last occasion, my lord, you'll recall there was some confusion as to whose security guards are deployed today at the property. I've taken that instruction, my lord. My lord, this is an email that we have received from our client. We have deployed our security guards, that is that Baba agency, my lord, which is recorded in our prior minutes of meetings on 17th February, as per this specific instruction. We've sought specific instruction on this. My lord, this is pursuant to a joint meeting between the advocate on record of the petitioner and the official liquidator. If my lord takes the supplementary affidavit once, that's been filed on the last occasion, but 17th February itself, my lord, the official liquidator directed their security agency, that is CAT-I, to withdraw, and we directed our security agency to go onto the property and to ensure that no encroachment is made. My lord, that is the status. 17th February onwards, my lord, our security guards are there. Now,
My instruction is not that. No intimation was there.
Their security was not, they have not deployed their security, sir.
that is our instructions. We will file. My lord,
deploy their security.
what basis my learned friend is making this submission, I don't know. Because my lord will kindly have 2 pages of their own supplementary affidavit. My lord, their supplementary affidavit, just 2 pages.
So on that day, we are ready to hand over the property to them, but they have not deployed their security, so we cannot hand over the property to them. We cannot withdraw the our property.
My lord, it is withdrawn. They've already written, my lord, supplementary affidavit, my lord, page 28, if my lord has once.
No, page 16, my lord, kindly see. Page 16 first. The email received from the CAT-I Security Services
My lord.
to the official liquidator.
So you do one thing.
My lord.
Or kindly see
I
the.
I am appointing a special officer. He will.
If they are taking over the position, taking over the deployed the security agency, I am withdraw our security.
That's already, that's
No,
instruction only what I was showing. My lord, one minute, my lord. 1 minute, my lord. Page 28 and 30, my lord, will kindly have a look. This is part of their own supplementary affidavit. They have written already to their security agency to withdraw. Page 28, my lord, is their joint minutes. I am not taking, my lord, through that. 29 directly, my lord, will come. My lord, will kindly see. They have already written to this CAT-I security. You are requested to withdraw security guard. Second line, please be informed.
Okay, I am
No, my lord,
I am
your
passing
lordship.
an order in terms of this email. I am passing an order. They are telling that
Yes,
they
yes,
already deputed their security guard, 4 numbers of security guard from the Baba. What is the name?
Baba agency, that was agreed upon also. Page 28, that is also
No, my lord,
Baba agency.
Yes.
So in terms of this, let this same be kept with the record, and you are directed in
Yes.
terms as they have already deployed the security guard. The officer liquidator withdraw the security guard.
Yes, my lord, kindly see the last order passed by your lordships. They have on that day, they said that just now we have received an intimation that our security guards have already been appointed from that date.
That was wrong, my lord. I
That was their
apologize on that
submission.
itself.
Correct.
That's why,
And my lord, kindly see the page 16 of my supplementary affidavit where the security guards are intimating to us that nobody has taken care of charge of these assets.
And the 17th January.
Yes, 17th January, because on that
Now
day
they are telling that February.
17th
They are
February.
telling that 17th February, and your last resolution is on 13th of February.
Yes.
13th of February. The meeting of so and so.
Yes.
Stated herein above submitted that the client will deploy their security guard through the Baba security agency at the factory. So I will record this and I will keep this email on record and direct that they already deployed, and the officer liquidator withdraw the security guard.
And let them, my lord, the payment of the security guard agency, my lord, at least from the day, my lord, the order was passed. 17th January, the order was passed.
No, 17th February we have deployed. We are paying, my lord. We are bearing the cost of our agency. We are not paying to their security guards. In respect of the arrears, my lord, page 17, my learned friend had indicated, CATI has raised a bill for a certain amount. That bill, my lord, the last entry is April 2023. The order, even the last order of the learned coordinate bench was 6 January 25. I cannot be burdened with whatever dues the official liquidator incurred. As it is my property. And the last bill is April 2023, as per their own document. So, my lord, whatever
But
dues
if
are.
they takes possession of the factory premises in, according to them, 17th February,
Yes.
in spite of the order of the 17th January, my lord, they should pay the that at least for that month.
There is no order of 17th January subject to correction.
No,
my lord.
but you have taken the resolution
Yes.
on 13th February.
Yes.
And that resolution, you have not taken any decision with regard to the payment. Kindly come to the page 28.
Yes.
6 January order. 6 January order.
Because that is the.
What is your application? You have filed any application?
Yes, my application, my lord. If my
What
lord
is your
takes the-
application for?
My application is for my lord disclaimer.
Huh?
Disclaimer of the property. This property does not belong to the official liquidator or the company in liquidation. They were sitting on my property. Already prayer A has been allowed. It is only physical possession which is left. In that regard, my lord, I can argue it here and now, my lord. Nothing else remains. Today, my security guards are already deployed. RCL, my lord, their mortgage has been categorically declared to be null and void by a competent court. There is no order of stay. There is an appeal, my lord. I am admitting there is an appeal. No order of stay. It is pending adjudication. Let RCL take whatever steps they want under the surface action.
Appeal decide.
Let the appeal be decided. My lord, in that regard, my lord, till then, my lord, I cannot be deprived of my property. If RCL gets.
That's why you have been given the you have deployed your security guard.
But my lord, symbolic possession is still with the liquidator. My lord will kindly have 6 January 2025 order once. Only once, my lord. 6 January 2025 order. That's also set out in a part of the supplementary affidavit, but my lord will have the order.
Lord, this is the email we have received from the CATI. That is the email dated, my lord, 18th February. They have intimated to us, this is to inform you that still my security continues and no one came on 17th February to 25 for taking possession of the land at Jharkhand. Lord, this is the email we have
Let a
received.
special officer go. I have no difficulty. My lord will appoint a special officer.
Yes, it's no problem.
This is not part of the supplementary affidavit either. I don't know where this email is
No,
coming
this is
from.
subsequent to the supplementary affidavit.
Supplementary
Supplementary
affidavit
was affirmed on
4th April 25. This is not part of the supplementary affidavit. Supplementary affidavit of 4th April. An email of February 25 is now shown. My lord will kindly have that order.
very well.
Towards the end, my lord, there is a line starting, it is apt that the possession of the present property should be retained by the official liquidator till final outcome of this litigation. Necessary steps shall be taken, including police protection, so and so, to rule out any encroachment and trespass onto the property. Private security guards may also be deployed for this purpose. Cost of this exercise shall, for the time being, be borne by the petitioner, that is my client, subject to further order in this regard. So now Muller will kindly dispose of this application. RCL are not interested in appearing. Last
No,
year,
but the appeal is pending.
appeal is pending. Muller will kindly appreciate. Muller will kindly appreciate this. Today, possession of the property is with my client in law, should be, because I am the owner of the property, undisputed. RCL is a mortgagee. Muller, a mortgagee has a right to recover possession once they invoke the mortgage. They are at liberty, Muller, to take action under the Surface Act if they so deem fit. They have not done so. Muller will kindly appreciate.
With the defendant number 3.
Defendant number 3 is RCL. RCL. They didn't appear last time also. Today they are not appearing.
Who?
RCL, Muller, as a secured creditor. Asset reconstruction company, Muller.
So they are not appearing.
They are not appearing. Last day also they did not appear. Muller will kindly appreciate. A mortgagee.
So unless they will, yeah, okay, I am fixing a date. You issue the notice. They will come. They will
I'll
come.
issue a notice. I'll issue a notice. And Muller can also appoint a special officer if Muller so deems fit.
Yes,
Let the
we
actual
have no
position.
problem. We
Let
have
the
no
actual
problem.
position be before Muller.
I will record here.
Yes.
I will record here.
Yes.
Yeah, in terms of
17th February. Yes.
You have deployed this, so
Yes.
they will withdraw this.
Yes, Muller. Yes.
That's all.
Alright.
If they you will not deploy, it is your risk.
Absolutely. It's my property at the end of the day.
It is
Yes.
your risk.
Yes.
So and so appearing for the official liquidator. so appearing for the, you are for the
I
petitioner?
am the petitioners in CA5, applicants in CA5 of
Applicant.
2023.
None appears on behalf of the respondent number 3.
Yes.
Full stop. The counsel for the applicant has handed over an email dated 25th of February 2025, wherein it is mentioned that the applicant has posted 4 security guards at the factory land site on and from 17th February 2025. Full stop. On the other hand, the learned advocate appearing for the official liquidator has handed over an email dated 18th of February 2025, wherein it is mentioned that still the CAT I security KATIEEYE security guard continues as no one come on 17 February 2025 for taking possession of the land at Jharkhand. Full stop. There is a dispute whether the applicant has posted any security guard or whether the security guard posted by the official liquidator are continuing in the property or not. To avoid any future complications, this court find that the applicant, by a communication dated 25th of February, the applicant submitted before this court, the applicant has already posted their security guard to secure the land and factory in question. And as such, this court is of the view, once the applicant has taken a decision that they have already submitted that they have already posted the security guard in the said factory and the land site to secure the property in question, this court presume that the applicant has already posted the security guard. In view of the above, if the security guard appointed by the official liquidator is still in the possession of, still in the said landed property, the official liquidator immediately withdraw the security guard. Full stop. It is made clear that this order is passed on the basis of the email dated 25th of February 2025 and the submission made on behalf of the applicant. In future, if any of the person will make any claim that the property has been encroached by the third party, it is the risk and cost of the applicant only, and the official liquidator will not be responsible for the same. Full stop. The
Not at least 1 month's the expenses
that subsequently I will decide.
Very
full stop. Let the matter appear. Full stop. Let the matter appear on 21st May.
Kindly direct them to serve the notice upon the security.
Because next time, my lord, we serve a notice on the respondent number 3. My lord can direct us to serve a notice.
As the defendant number, as the respondent number 3 is not present, and as such, it is not possible for this court to take up the hearing of CA5 of 2023. Accordingly, the petition is directed to issue notice upon the respondent number 3, intimating the date of hearing of CA5 of 2023. It is made clear that in spite of receipt of the notice, if the respondent number 3 failed to appear before this court, the CA number 5 2023 filed by the applicant will be taken up for hearing in the absence of the respondent number. This is the matter on 21st of May 2025.
Deeply.
Nobody. Not today.
Lordship, regarding item number 21, Your Lordship, I'm praying for time because I've been instructed to appear, but I have not got the papers. Your
Not today.
22 and 23 are the same prayer. Your I'm just praying for a week's
Not today, not today, not today.
Great.
23, 24. 24.
Not today.
25.
So in this in 25, in this matter, we have already handed over the position to IRP.
Handed over the possession to
RP, resolution professional.
So
in terms
what
of
can
the
be done?
order.
File a report stating that
Yes.
the so-and-so and the official liquidator is present and press for time to file report. Let the report be filed within 2 weeks. Release the matter on 15th May. Not 15th, 14th May. Yes. Not today. Not today. Not today.
Lordship, in this matter, I am for the official liquidator. Lordship, I am praying for 1 week time for filing auditor's certificate. Lordship, there was an order passed by Honorable Justice Sugata Majumdar to file a auditor's certificate. Lordship, so I
As
am
per the
praying.
so-and-so appearing for the official liquidator. Full stop. So-and-so appearing for the official liquidator. As per the submission made by the counsel for the official liquidator. Time to file auditor's certificate.
Yes, Lordship.
Auditor certificate is
As to the order passed by Honorable Justice
extended for a further period of 2 weeks. 2 weeks. Release the matter on 14th May. Next. Not today. Not today.
Lordship, 32, I am for the official liquidator. This is a complaint matter. Summons be issued against the directors of the company, directors of the company, for not filing this statement of affairs, Lordship.
When the last order was passed, whether they have appeared,
No.
they're not
Lordship,
appeared.
No.
Summons issued.
No, that's why I am praying for
No,
issuance of summons against the director.
Because on the last occasion also, then I find that it will come next week as a to be mentioned. In that also, the summon was issued. They are one of the
In this matter, Lordship, in another matter, Lordship.
another matter.
Yes,
That's why I want to see.
I do not know
Summon
whether
issued.
issued. We have filed these applications on 5th April 2021, Lordship.
Yes, summon issued. Could not be served upon the accused person. I could not be found at the given address. In spite of that is the 3 now, third. How many persons are there?
Lordship, if your Lordships kindly come at page 7, para 7, there are 3 directors, Lordship. Dipankar Basu, Rajiv Pal and Raghu Jaya Sethi.
Dipankar, Rajiv and
Raghu Jaya Sethi.
Raghu Jaya Sethi.
Yes, sir.
Service Rajiv.
Whether they have received, Lordship?
Dipankar Basu received regarding other two, it is not served. Dipankar Basu only served. Other two not served.
Then again,
So to take appropriate steps. So-and-so appearing for the complainant / official liquidator. Official liquidator.
I am for the official liquidator.
Correct. Complainant.
I am the complainant.
Full stop. It is fine from the process. It is fine from the service report. The notice was served only upon the Dipankar Basu on 23rd August 2021. As regard the notice upon the other two accused persons could not be served. Accordingly, the complainant is directed to take appropriate steps for issuance of fresh notice upon the Rajiv Pal and Raghu Jaya Sethi within a period of 2 weeks from date. List the matter on 21st of May 2025. Yes. Not today.
Lordship, this is also a complaint matter. Summons
34 main.
Summons be issued against the director for non-filing a statement in affairs in spite of several requests.
How many
Lordship.
accused persons? 5.
Lordship 5.
You are appearing for?
I am for my creditors. The main application has gone into liquidation. They have taken possession. My only one submission. Let their application. I have nothing to say. Kindly direct the officer to sell out and distribute them a lot. Claim of the creditors. We are.
That application is not here.
Isn't it?
It is only
Right,
CA2.
it is a complaint matter.
It is a complaint petition.
Yes, Lordship. Your Lordships kindly fix a matter that
Along with this
main matter.
main matter. Only one direction upon the official liquidator. Sell it out and my lord, distribute them all, claim of them all, creditors. So maximum are admitted by them.
I think in this matter, summons were not issued, Lordship.
And next week,
No
all
report.
the matters.
Served upon the accused person Alok. 2.
No, jail water.
Then served upon the person as per report SI.
Jail charge.
Respondent number 3, Lordship.
Jail
Bar Council Chair.
তাহলে কি আলাদা 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 হ্যাঁ
Here out of 5 only 1 has been served. Other has not been served. It okay.
नेक्स्ट क्या करते हैं एक
तो सर्विस
कल करने दिया ये लोग ऑफिशियल মেন সিএসসিটা নাম মনে আছে মেন সিএসসি
served upon whom?
একে জিজ্ঞেস করো ওই
Served on whom?
রঞ্জন বলতে পারো।
মেন সিএসসি
Case number 1. Okay. Accused number 1. Acha, this one. Two and 3 had been served. 1 and 5 has not been served. 1, 4 and 5 have not been served. So appearing for the complainant / official liquidator. None appears on behalf of the accused 2 and 3 in spite of service of notice. Full stop. No notice has been served upon the accused 1, 4 and 5. Full stop. The complainant is directed to take fresh step for service of notice upon the accused 1, 4 and 5 within a week from date. List the matter on 21st of May.
21st.
Well, main application be come with
What is the
all
number?
pop.
I'm
giving
CP
number
the office is directed to place the CP number 405 of 2016 on the next date fixed along with CA 11 of 2020.
I'm
C number. Deep problems. Then all problems.
So any other matter, company matter, any persons are there?
35.
Or come on the next week?
Number 39.
35, my 35. 35. I am for the complainant official liquidator, my lord.
Notice served?
Notice served, my lord.
When? You have a report?
Notice served on 10th January 2017, 2019 and 29th March 2017. Thrice, my lord.
They not appeared?
No, my lord, one of them appeared. Out of 3 directors, one of them appeared, my lord.
So?
No one, thereafter no one appeared, my lord.
How many accused are there?
Three.
Three. Who has appeared? One appeared.
Yes, my lord.
Satyendra Badani.
No, my lord.
Gopal Prasad.
My lord, Gopal Prasad.
Gopal Prasad appeared.
My lord.
And what are this? All three have been served.
Lordship.
You are having the report. How you can say it is served?
Have not yet filed statement of file. My lord, already filed a report. Annexure B, my lord, page 17, my lord.
How in the complaint you will give the report?
It is in the order sheet, my lord. In the order sheet dated 7th December 2018, it is reflected that the official liquidator has filed a report that in spite of notice issued to the ex-directors of the company in liquidation mentioned in paragraph 8 of the report.
Which date? Which order?
Order dated 7th December 2018, page 17, Annexure B.
Of which?
CA 106 of 2019.
There's no report. This is a complaint.
Annexure B, my lord. Page 17, my lord. Your order passed by Honorable Justice Ashish Kumar Chakraborty.
Officer required file a report in spite of notice issued to ex-director company. Paragraph 8 report has been not filed by the statement. Therefore, the officer. Correct. See, that's why this is a complaint case.
Lordship.
After issuance of notice, they have not come before you and they have not filed the statement.
Nothing.
That's why you have filed a complaint case under 454(5) and 5 capital A.
Lordship.
Correct.
Lordship.
So now the notice has to be issued.
Lordship.
So whether that's why you ask.
No. That
so
notice.
what you are telling? So and so appearing for the complainant. The complainant has filed the present complaint case against the accused persons on the allegation that in spite of receipt of the notice, the ex-directors of the company have not filed their statement of affairs under section 454 of the Companies Act 1954. And accordingly, the complainant has filed the present application on the allegation that the ex-directors, that is accused persons, have committed an offence under section 454 within bracket 5 and 5 capital A of the Companies Act 1956. In view of the above, this court find that the accused persons have not submitted their statement accounts in spite of the opportunity given by the official liquidator. Issue. The complainant is directed to take appropriate steps for. Then the department is directed to take to issue summons upon the accused persons, returnable by 4 weeks. Local?
No, not local, my lord.
Jharkhand. Issue. Department directed to take appropriate steps for issuance of summons upon the issuance.
2 is Jharkhand, 1 is Bihar.
The accused persons, returnable by 18th June 2025. Yes. All next week. Remaining next week, come next week. I have another matter. Okay. 36. Number 8. Yes. Deposited, not deposited.
Lordship, we have gone to the register, Your Lordship. However, due to that 12% interest, Your Lordship, we could not submit it. He did not. He refused to take this, Your Lordship. It is the original one. I have spoken to the client. It's the original one. the demand draft.
So what can be done? The appellate court has not allowed you with regard to the time. So I am passing an order for the affidavit. Affidavit assets. What can be done?
Your Lordship, we have already filed an application before the appellate court,
neither here
which
nor
will be
there.
listed on Monday itself, Your Lordship. If Your
No
Lordship could
problem.
allow us.
Our application will also be listed, Your Lordship, along with that application.
No problem. I am passing an order. You get in this. What can be done? You are not depositing. I have given so
Your
many
Lordship,
time.
we had gone to the registrar, Your Lordship, and Your Lordship, this DD has been confirmed as being original, Your Lordship.
So what has
Yes.
happened?
No, Your Lordship, we need an opportunity to,
When you went to register?
right after Your Lordship told us, Your Lordship, because
After
there were,
lunch you had been?
no, Your Lordship, before lunch, right after we,
After
Your
the
Lordship.
lunch,
had
the
directed.
registrar came to me. I advised I accept you. You are not went to the office.
No, Your Lordship, we had gone.
When?
You can call
After
Your
lunch you went.
Before lunch, Your Lordship.
That's why I'm asking. After lunch you had been.
After lunch, he asked you to come. She's my advocate on record.
After lunch, nobody had been to the registrar office because there was a confusion with the registrar. Registrar came to my office after during lunch period. I had directed him accept it.
The registrar asked my advocate on record. He said, if the court directs in writing, and if you give me that order in writing, then I will accept it.
That is before recess. After recess, you have not been to.
After recess, you didn't go. Why didn't you go after the recess?
Because he did not ask me to go. He rejected it. He said he will not accept it.
She was told, Your Lordship, that he will not accept it. Therefore, she did not go. Your Lordship. She said she was told that if the court directs, क्या बोलছে?
So appearing for that.
Lordship, we are willing to do this, Your Lordship.
So appearing for the judgment debtors.
Your Lordship, we have made earnest endeavors, Your Lordship, from our end, Your Lordship. We bow down before Your Lordship. What is Your Lordship?
First order was passed on 7th April. You have taken time till 10th April. You have made the DD on 11th April.
Your Lordship,
Now
the
today we are
client
on
came on that day, Your
16th
Lordship. He is
April,
in Delhi,
16th
Your
April,
Lordship.
morning 10 o'clock and 10:30 I have given. This court has given time till 3:45.
Lordship, we went to the registrar. He refused, Your Lordship.
You refused. You could have been mentioned here before the rising of the court. You are not mentioned also.
Your Lordship.
But the registrar Somoto came to my office chamber. I advised my registrar if they will come, you take it.
We'll give it right now, Your Lordship.
Now, the 4:30, how the...
We were told you go to the court and you seek an order, Your Lordship. How would we know, Your Lordship? After he refused, how would we know that he would accept it, Your Lordship? Your Lordship, we bow down. Whatever Your Lordship deems fit, Your Lordship. We bow down before Your Lordship.
The judgment debtor.
Your Lordship, we would only request if you could give us time till next week. Your Lordship,
Your
we
Lordship
have already
cannot.
moved the application before
Your
the appellate court.
your applications already dismissed by the appellate court, not granted time.
There's no stay.
Even I have granted time for a week.
Your Lordship, we bow down, Your Lordship, before Your
Lordship.
It has been going on
What the
since
court will
September.
Your Lordship will.
What the court will do.
Your Lordship, we will go right now and do it if he accepts it, Your Lordship. If he accepts, he's spoken to Your Lordship, we'll do the needful right now, Your Lordship.
The judgment.
I undertake personally, Your Lordship, that I shall oversee that my advocate on record goes, Your Lordship.
The judgment debtor number 1 has
number 2, Your
ready, and judgment debtor number 2 is ready with the demand draft of rupees 34 lakhs of Punjab National Bank.
Standard Chartered Bank.
Of Standard Chartered Bank, Bombay branch. Which area?
Lordship, Pay Center, Mumbai. STS Pay Center.
STS Pay Center, Mumbai branch. Full stop. Full stop. The counsel for the judgment debtor number 2 press for a week time to pay the interest at the rate of 18%.
12%, my lord,
12%.
that comes to around 38 lakhs.
12% in terms of...
What is the amount that you want us to, since we do not have the copy of the application?
There's no question of wanting anything. It is the decree will speak for itself.
12% from the...
Decree is very clear.
38
calculate.
On the principal amount of rupees...
Sorry, I mean number...
34 lakhs within a week from date. Full stop. Considering the submission made by the counsel for the judgment debtor number 2, the judgment debtor is directed to deposit the said demand draft in the before the registrar or original side of this court in course of the day, and to further deposit the interest at the rate of 12% from
7
12%
January,
in terms of the decree passed by this court till 11th of April 2025
7 January 2016.
by 24th of April 2025. Please the matter on 25th of April 2025.
Deeply obliged.
I'm grateful to it.
Go.
I will, Your Lordship. Right now, Your Lordship.